and thank you all very much for coming. I'm Paul Truster, head of CLE for the Law Society. Very pleased to welcome you to today's program, which will begin in just a moment. I'll begin by thanking our faculty. We're certainly very honored to have Mr. Justice Laskin with us today, and we're indeed honored by all our faculty who have been honored to have all our faculty who've given very generously of their time and talents in preparing the materials you have before you and the presentations you'll see and hear today. We're obviously completely dependent on their efforts, and as I say, very grateful for them. You should all have a binder of program materials, and I just want to take a moment to point out the gray course evaluation form, which lies just a few pages into those materials. We take these very seriously. They're of great assistance to us in planning programming that will best meet your practice needs. And so you would be doing us a great favor to complete that form by the end of the program and to leave it at the registration desk outside. If for any reason that's not possible, please do complete it and send it in after the program. However it arrives, by mail, by fax, by carrier pigeon, it will be read and it will be considered seriously. Our chairs and indeed many of our faculty will already be well known to you from previous programs. Their biographies are contained in the course evaluation forms, so I won't dwell on them here, but I certainly will take a moment to introduce our chairs. To my immediate left, Matt Certosimo, and just to the left of Mr. Justice Laskin, Randy Echlin, who I understand will be the next to speak this morning. So please join me in welcoming our chairs. Thank you.
Thank you, Paul. Welcome to you all to the fourth annual 6-Minute Employment Lawyer. We're quite pleased that it's one of the Law Society's largest CLE programs. We have 21 very good speakers today. But with that comes some responsibility. And those of you who have been to previous 6-Minute Lawyers know that we mean it's 6 minutes. It's not 6.5, it's not 7, it's not anything beyond 6. And that's why we use the magic lemon. This is an egg timer that will gong the speaker when they go over their time. So it's totally impersonal. It's not me, it's not Matt, it's the egg timer. But join me in welcoming our first speaker, my good friend John Laskin, who I realized this morning has now been on the Court of Appeal 8 years. He's was first appointed in January of 1994 and is certainly a leader amongst what the bar refers to as the Dream Team. It's probably the finest court in the common law world. And I mean that quite sincerely, John. You'll note when John speaks today that his voice is a little husky. There's a rumor that somebody looking like John, wearing a purple Raptor headband, was at the game on Friday night, and again yesterday, and was cheering them on. We're indeed fortunate to have Mr. Justice Laskin with us to share his view from the bench. John?
Like Randy, I am a passionate Toronto Raptors basketball fan, so it's going to be a little tougher to speak to you this morning after the loss yesterday afternoon. I want to first of all commend both Randy and Matt for organizing this program, and also commend the speakers for contributing to it. Programs like this, of course, are of great benefit to all of you down there. Just witness the number of you that are there. But programs like this are also of terrific benefit to the court. All of us on the court struggle to a greater or lesser degree with the inevitable isolation that comes with the judicial office. It's not just that we can't sort of share the same camaraderie with the bar that we used to when we were in practice, and that's bad enough. But also, we sort of risk, I think, at times getting a little bit out of touch with what's really going on sort of on the street in the real world of law. And I think programs like this really help us a lot, because all of you are discussing sort of the current and important issues of the day in employment law, critiquing our judgments, commenting on our judgments, and all of that, it seems to me, helps to make us current and helps us to do our job better. Now, employment law appeals, we don't track actually the number of employment law appeals that we have in our court, but my sense is that they are a significant component of our civil appeals inventory. And because we no longer have a backlog in our court and haven't had a backlog for some time, all of those appeals are heard within 6 months of perfection. And because we don't have a backlog, I think one of the consequences on our court is that we've all started to write a lot more in terms of full-length judgments. And in the heady days of 3 or 4 years ago, when we were trying to eliminate our backlog, we were probably disposing of an awful lot of cases by endorsement that, quite frankly, probably deserved fuller consideration. Well, now that we've got sort of the luxury of time, I think we're writing a lot more, and we're writing a lot more in areas like employment law. But to borrow a phrase from diving competitions, the DD, the degree of difficulty, has got a lot harder, I think, because we sort of seem to have cleared out most of the easy cases from the system, and the cases that we now seem to have in our court, I think to all of us seem a lot tougher. So with that background, I'm just going to spend a few minutes and tell you sort of in a nutshell what I think we've been doing in the employment law field over the past 12 to 15 months or so. And I divide the cases that have come to our court into sort of 3 general categories. The first category I would say I would categorize as appeals from findings of just cause or findings of no just cause, and from periods of notice fixed by trial judges in wrongful dismissal cases. Now, these continue to be difficult cases for appellants to win, quite frankly. Our court continues to take seriously the principle of deference to the trial court. And when you're in the area of employment law, there are 2 aspects to deference that are really important. First of all, when you're talking about findings of fact or findings of credibility, and whether it's based on an oral record or whether it's based on documents or a written record, palpable and overriding error remains the threshold. I never really liked that phrase very much, quite frankly, and I sort of equate it to a standard of unreasonableness. But whatever phrase you use, the threshold is very high, and we take deference pretty seriously, and it's tough, real tough, to overturn findings of fact or findings of credibility in our court. So that's one side of it. The other side of it is really the notice period side. And the bottom line message, I think, is that we don't tinker. We don't tinker with notice periods. Just because we might have put the period at 15 months and the trial judge put it at 18, or we might have put it at 9 and the trial judge put it at 6, we're not in the business of adjusting if the notice period comes within what we would generously call a range of reasonableness. And it's sort of like the way we treat sentence appeals or the way we treat support orders in family cases. We simply aren't going to tinker. So those cases are tough. Now I turn to my second category, which I would sort of call the application of established legal principles to new fact situations. And let me just give you a couple of examples. One is Felker, which I think created quite a stir when it came out, at least in the popular press. Didn't create nearly the same kind of stir in the sort of hallways of Osgoode Hall, because I think in many ways our court looked at Felker as simply a reaffirmation of the principles established by the Supreme Court of Canada in Can, Arrow, and O'Malley. And the principle is, if you're a key employee in a fiduciary relationship with your employer, then you've got duties of absolute loyalty and full disclosure. And if you're going to negotiate for yourself an important employment opportunity on company time without disclosing it, well, you open yourself up to the risk of a lawsuit of having the defense of just cause raised against your wrongful dismissal claim. Then there's Lyons and Multerry and I guess related Ash Temple, 2 judgments written by my colleague and good friend Jim McPherson, which are also in a way an application of Justice Dixon's judgment in Elsley and Collins. And I think the 2 lessons that come out of Lyons and Multerry are, first of all, when you're inquiring into the reasonableness of a non-competition covenant, and that's what was an issue in that case, it's a very fact-specific inquiry. And if you look at Jim McPherson's judgment and the trial judgment in Multerry, it's very fact-specific on the reasonableness of the non-competition covenant. And the second lesson is, I guess, if you're negotiating an employment contract for your client, you got to think long and hard as to whether a non-solicitation clause will adequately protect your client's interest without going the further step, the more drastic step in the arsenal, as Jim McPherson called it, of drafting a non-competition clause as well. Then there's Shaw and Xerox, which is actually a case that I sat on, which is a constructive dismissal case and is, at one level, is an application of Farber and Royal Trust in a sort of odd way. I mean, the issue in Shaw and Xerox was whether you could make out a constructive dismissal even though you couldn't point to a specific important term of the employment contract that had been breached. And the trial judge said yes. Justice Cullity said yes because the employer's whole conduct showed an overall intention not to be bound by the terms of the employment arrangement, because there had been continual unjustified criticisms of Mr. Shaw's job performance over a long period of time. Now, that's at one level, and even at that level, I think is faithful to Justice Gontiier's judgment in Farber and Royal Trust. But at another level, Shaw and Xerox really shows that most cases turn on their facts, because the reality is that the trial judge and our court thought that this employee had been very badly treated by his employer, very badly treated, and the trial judge was going to go and find a way to help him. And the trial judge went and found a way to help him, and maybe in the eyes of some didn't sort of cross his T's and dot his I's in the way that maybe he should have, but overall the judgment seemed to us to be pretty fair, and we too were going to find a way to uphold it. So you always, in a way, have to look at these cases, not just in terms of sort of their legal principles that seem to be on the surface. Sometimes you really have to get underneath these cases and really look at the underlying facts and the equities of the case and recognize that all of us, even on our Court of Appeal, are much more concerned really with doing equity between the parties, with doing justice between the parties, rather than, and we'll bend the law a little bit if we have to achieve what we think is a fair and just result. Hainan and Frito-Lay, which is a little older case, about 14 or 15 months ago, shows our court's continuing concern with employers using findings of administrative hearings, be it employment standards or unemployment insurance, to then raise the defense of issue estoppel in a wrongful dismissal case. And we've written several judgments in the last year or two which are trying to confine the application of issue estoppel in those cases. So that's the second category of case. The third category of case, and I'll just spend a minute on it because I'm probably over my time already, even though there's no egg timer, is the courts trying to establish new principles in certain areas. And I just mentioned a couple of cases quickly. One is Tominko, which was just released, I think, within the last 3 weeks. It's a judgment of our Associate Chief Justice, Calder Osborne. It's an Occupational Health and Safety Act case in which there was a lot of confusion out in the profession about what the Crown had to show to prove a breach of the Act. There was an endorsement of our court called Grant Paving, which had caused a lot of confusion out in the real world, and Justice Osborne wrote a decision in which he basically said that the actus reus of an offense under the Occupational Health and Safety Act, unless there's some magic words like knowingly or willfully or so on, doesn't include a mental element. And in this case, the Crown didn't have to show that the employer knew of a particular hazard in order to found a conviction. And I think cleared up a lot of confusion in the law. So it's an important point for those who have to worry in the employment field about dealing with charges under the Occupational Health and Safety Act. There's also another very important part of Tominko, which is more general application, and that is the value of our endorsements. When I first came to the court, coming from the civil side, I'd sort of almost never heard of the notion of endorsement. But now it's with computers and so on, all of the bar throws in front of us on a daily basis or throws back at us are endorsements in varying cases. And sometimes our endorsements might not be thought out as carefully as we might have wished in retrospect. And Chief Justice Osborne in Tominko has at least written to say, look, yes, endorsements still have precedential value, but don't take them too far. Don't read into our endorsements sort of overarching principles of law. Treat them for what they are, very fact-specific decisions. Greba is another case, and I'm not going to spend very much time on it because you're going to get a little talk on it later, I think, on the stock option part. But another very important aspect of Greba and Moneta, and I invite you to look at it, is the discussion of mitigation and the discussion of the extent to which, and the employee in that case who had been dismissed within the notice period had gone out and staked the number of mining claims. And the question was whether, when you came to calculate the damages and the offset for mitigation, whether you should bring into account the mining claims that he had staked in the mitigation, in the notice period. And our court divided on that issue, 2-1, 2 holding no, and Justice Finlayson in dissent holding that they should have been brought into account. And the analysis in that case, I think, is very important in terms of looking at a very unusual but perhaps important aspect of mitigation damages. And then perhaps lastly is Entrop and Imperial Oil, which of course deals with drug and alcohol testing in the workplace. And our court held that if the policy is reasonable, alcohol testing in the workplace for safety-sensitive jobs will not run afoul of the Ontario Human Rights Code, but drug testing will. Why? Because on current technology, breathalyzers can measure actual job impairment. There is no equivalent test for drug testing. Positive test doesn't necessarily show impairment on the job. So, in about 5 or 10 minutes, that's a pretty brief survey of what our court has done over the past 15 months, perhaps all too brief. But I know that you're going to get some more in-depth discussion, and I hope useful critique and commentary on some of these cases throughout the morning. So thank you very much for your attention.
Get on.
What was that?
Justice Laskin described it as a brief survey, but I think we would all agree that was a rather sweeping survey of the role of the Court of Appeal, and in many of those cases, Justice Laskin himself, in important cases that we'll be assessing in a little bit more detail over the course of the day. We were truly honored when Justice Laskin agreed to give us the view from the bench this morning to kick things off, and I think you'll agree after listening to that 10 or 15-minute presentation that we were very, very fortunate indeed to have him here this morning. Please join me again in thanking Justice Laskin.
Thank you very much.
We know that you have important matters to attend.
I'm going to stay and listen to a couple of our judgments get critiqued here.
Keep that in mind, speakers. A few years ago, I guess it was after the first 6-minute employment lawyer, the feedback we received, while positive about the success at keeping lawyers to such a short speaking time, recognized that some of the topics that were addressed necessitated a little bit more time to discuss, to assess, to analyze. And so we started out about 3 years ago with the special section on, as we call it. And initially it was the employment contract. Last year we did the sale of the business from an employment lawyer's perspective. And this year, thanks to the Ontario government, we have a new Employment Standards Act to assess in a little bit more detail. The Employment Standards Act 2000 was introduced for first reading in early November of last year, and within a month it was passed third reading in order to allow for certain sections, those dealing with maternity leave provisions, to be in force and effect in time for the new employment insurance provisions dealing with mat leave. But the rest of the Act remains in a state of limbo while the government is drafting regulations. For those of you who have looked at the Act, and I don't want to steal any of the thunder of our speakers, but for those of you who have looked at the Act, you'll see that much of the old Employment Standards Act, which is still the current Employment Standards Act, has been shoved into the regulations. And we are still awaiting those regulations to see exactly how they're going to address, for example, exemptions to termination and severance pay. That's just one example offhand that comes to mind. But in addition to that, A number of new categories of matters will be addressed through regulation, such as the definition of constructive dismissal. Apparently will now be will be dealt with in regulation, as will the application of frustration. So there are a number of question marks surrounding the new Employment Standards Act, and rumor has it that in August those regulations will be introduced, so sometime before the end of the year we will have a new Employment Standards Act. So look for those regulations at a bookstore near you, because apparently they're going to make all the world's difference in how we apply this new act. Now, without further ado, I want to turn to our first speaker. Robert Parry is, without a doubt, the best person to kick off our discussion on the Employment Standards Act, at least from the bar's perspective. He is the author of the Employment Standards Handbook, and for some 20 or so years he has been a leading labor and employment practitioner. He's a partner at Matthews, Dinsdale and Clark, and we're very fortunate indeed to have him discuss the enforcement provisions in the new act. Robert, while you're on your way up here, perhaps I could just say that for those of you who haven't seen these new provisions, it may seem a bit back-assward to start with enforcement rather than with some of the substantive provisions. But I think you'll see after Robert's presentation that quite the contrary, some of the most significant additions and changes to the new Employment Standards Act have to do, in fact, with enforcement. So without further ado, Robert Parry.
Thank you, Matt. Mr. Justice Laskin is a hard presentation to follow, but let's see what we can do here. Bill 147, the new Employment Standards 2000, has imposed some dramatic changes in terms of administration, procedure, and enforcement under the Act. And those changes are expected to be proclaimed in force prior to the fall session of the legislature. The minister is speaking at a conference in September, and the organizers of that conference have pretty well received an undertaking from him that he wants this act and the regulations in place prior to that conference. I'd like to share some of the highlights of these specific changes in enforcement and administration with you. Labor Relations Officers. I'm not going to dwell on the power of the Employment Standards Officer. I want to focus on the new powers of the Labor Relations Officer. Those officers have typically played a mediation role at the Labor Board in dealing with employment standards appeals. Now, that role has not really changed in substance, but the Labor Relations Officer now has greatly expanded powers and discretion. In addition to the mediation role that they've always carried, that role now, on the direction of the board, includes substantial investigation powers. Specifically, the same powers given to an Employment Standards Officer under Sections 90 and 91 of the new Act now apply to a Labor Relations Officer, with the necessary modifications. Those are the key words. We don't yet know what that is going to mean at the board. And in that regard, I draw your attention to those powers that are set out on page 2-4 of the paper, and in particular paragraphs C, D, and F. Note that these are powers which allow the officer to require production or removal of documents or question any person where the officer thinks it may be relevant. Ladies and gentlemen, I leave it to you to contemplate how you would question or challenge that degree of discretion. Now, those powers are subject to certain procedural safeguards, and those are set out on page 2-5 of the paper. You should also note that the Act contemplates that a justice of the peace may issue a warrant authorizing a Labor Relations Officer to enter premises and search where the Labor Relations Officer has been refused a right of entry or where there's reasonable grounds to believe that the officer will be refused right of entry. And it's worth noting that the Bill 147 imposes a new duty on employment standards officers to follow policies established by the director within the branch. I'm sure some of you, most of you, are aware of the Employment Standards Interpretation Guide, an internal policy manual used by the branch. There's no secret those officers, hit and miss, will follow that manual. Now it's mandatory. But please note that that duty imposed on employment standards officers does not apply to a labor relations officer. So you've got the anomaly, perhaps, of an employment standards officer following the manual, doing an investigation, an appeal ends up at the labor board, and the labor relations officer is not required to follow the same policy imposed on that officer. I'm suggesting that you remain alert to some of those concerns, whether your client is an employer or an employee. Employer's duties. Any person is prohibited from attempting to or from hindering, obstructing, or interfering with an officer conducting an investigation. And those words, any person, are broad enough to cover an employer, an employee, or anyone else involved in the investigation. And there's more specific prohibitions are set out at the bottom of page 2-6, and they're worth reviewing at your leisure. Penalties, a happy topic. Where a person has been convicted of a general offense or a repeat offense, Bill 147 has prescribed significant fines. If the person is an individual, a fine of not more than $50,000 or up to 12 months imprisonment, or both. If the person is a corporation, a fine of up to $100,000 for the first offense, up to $250,000 for a second, and up to $500,000 for subsequent convictions. The Act also prescribes specific offenses, and examples are given on page 2-7 of the paper. Now, if an employer is convicted under the general offense provisions, other than the reprisal provisions of Section 74, the Act requires the court to assess and order the employer to pay any arrears to the director. Reprisal. This is very important, and it's been expanded. Section 74 defines what is meant by reprisal, and I've set those out for you, that definition on page 2-8 of the paper. In addition to this expanded definition of reprisal, I'd ask you to note that the bill imposes a reverse onus on an employer in any proceeding under the Act to prove that the employer did not contravene any of the provisions of Section 74. Those of you with any experience at the Labor Board dealing with unfair labor practices will appreciate the significance of that reverse onus. And the only exception to that reverse onus is where an employer has applied for a review of a notice of contravention, in which case the reverse onus rests with the director. Where an employer is convicted under the reprisal provisions, the court is required in mandatory terms to order the employer to take or refrain from taking specific action to remedy that contravention. And in addition, the court may require the employer to pay any wages. Should an employer be foolish enough to refuse or fail to comply with a court order relating to Section 74, please note that if that is an individual, there's a fine of not more than $2,000 for each day the failure to comply continues, or to imprisonment for up to 6 months or both. And if the employer is a corporation, up to $4,000 for each day the failure to comply continues. And those penalties are in addition to the penalties prescribed for conviction in the first instance. I'd like to briefly speak to you about how your employer client becomes involved with the act, the procedure you would expect as counsel, and some of the pitfalls on the way. An employee, other than an employee covered by a trade union or represented by a trade union, may file a complaint with the Employment Standards Branch, not the Labor Board. And that complaint must be filed in a prescribed form. If not, it's deemed not to have been filed. Once the complaint is filed, the ministry will usually provide the complainant with a form letter and instruct the complainant to send that to the employer, demanding payment. If the employer refuses or fails to comply with that letter, the officer will call a fact-finding meeting, giving the employer 15 days written notice of that meeting. This was initially established by policy. It's now incorporated into the Act. And at that fact-finding meeting, the officer may require the attendance of the complainant, the employer, an officer or director of the corporation, or any other person, along with records, and those will be specified in the notice. A person receiving notice of fact-finding meeting must comply with that notice. If the employer does not attend the meeting, expect the officer to make a ruling regardless, and that ruling may include an order to pay. If the employer intends to appeal the order must be paid and appealed within 30 days. Please note that was 45 days, so they've chopped the time limit back. Do not expect to receive an adjournment of a fact-finding meeting. If you, as counsel for an employer, cannot attend that fact-finding meeting, I strongly recommend that you send a letter indicating you will not be attending and without prejudice to your position on the merits. You may find that to be of some benefit later on in further proceedings. If the employer does attend, two possibilities. The officer can instruct the employer to do a self-audit and pay direct, or they can issue an order to pay. Don't expect the board on an appeal to listen to your complaints about the fact-finding meeting. Don't expect to cry the blues over the fact that evidence at the fact-finding meeting was not under oath. Don't go with sour grapes. An appeal before the board is a trial de novo, so you're going to have every opportunity to lead your evidence. The statute contemplates settlements. We've dealt with that in the paper. There's two new guns in the arsenal of the Employment Standards Officer. A compliance order. This is new. Please stop now. Are you going to ring that lemon or? Compliance orders and notices of contravention. They're dealt with at page 12 and 13 of the paper. I think I've covered the highlights. I encourage you to become familiar with Bill 147 and the pending regulations. My time's up. If you want copies of the board's rules of procedure, you can reach them at 416-326-7500. They will send those rules to you. Hope that's of some help to you. Thank you for your courtesy.
Think about those notices of contravention for a moment, or notices of compliance, notices of contravention, where the belief of the officer that your employer client is in contravention is going to be sufficient to issue one of these notices. And if your employer client, if you're acting for the employer, doesn't appeal that notice within 30 days, I think it is, your client, the employer, will be deemed to be in contravention. And that's kind of an interesting situation, because typically I think we'd all agree it'll be someplace around the 29th day when we'll receive the phone call from the employer client asking what they should do about this funny letter they received from the Ministry of Labor. The practices that we put in place with our clients, I think, are going to have to undergo an interesting change as a result of some of these procedural changes pointed out by Robert. People at the back, this is a new room for us, as some of you will know. I'm wondering, people at the back, are you having any difficulty hearing us? There's a sort of a two-level ceiling thing happening here. It may affect volume at the back. I guess if there's going to be a revolution at the back, we'll know it soon enough. But please tell us if at any point you're having difficulty hearing. Our next topic, hours of work, overtime, holidays, and vacations, was to be presented by Neil Summer, but Neil is involved in a trial, and as a result, his colleague, Jonathan Cocker, has jumped in. Now, Jonathan spent a number of years working at the Management Board Secretariat in the Government of Ontario, arbitrating about 15 arbitrations a day, I think it probably was, Jonathan, right? In government against OPSU, I think, primarily. So he's extremely experienced, but because of that experience and talent, he was lured away from the government, hopefully with promises of grandeur, by Baker McKenzie sometime about 2 years ago. His practice has evolved into all areas of labor and employment law. Maybe, Jonathan, I could get you to come up here now. We're going to do hours of work, overtime, holidays, and vacations, all of which have received some adjustment and change in the Employment Standards Act 2000.
Thanks very much. If I appear reticent coming to the mic, it's actually that I ran my first marathon yesterday, so don't take it personally. Won't be my last, but anyway. As Matt has indicated, I used to practice with the Government of Ontario, and I believe that it may provide me with a certain amount of insight into the legislative process with respect to the regulations. As you've heard from Matt and also from Robert, there's going to be a fair amount in the regulations that was previously in the Employment Standards Act itself. And when I hear that the projected date for the completion of the regs is sometime in August, I must say I do bat an eye, because when I recall seeing similar initiatives in previous years, I can tell you that July and August were not the months where a lot of things were completed. And perhaps I can further add that I do in fact know the lawyer who's been charged with the task of drafting the regulations. She's a young but very capable lawyer, and when I tried to press her as to when exactly we'd see these regulations, she simply told me that they will get done when they get done. So I don't know that we're going to see these rolled out in September, but like the rest of us, I certainly hope so, because it's obviously the last piece of the puzzle in terms of what exactly the Employment Standards Act 2000 is going to look like. On that note, I am going to speak to you about 4 separate areas under the Act: hours of work, overtime, vacations, and public holidays. And I have a few comments which I believe apply to all 4 areas with respect to the Employment Standards Act 2000. First of all, this Act appears to be driven by a greater concern for flexibility. So you'll see in certain provisions with respect to all 4 areas, there's a greater concern with a more flexible workplace. And I think that perhaps reflects the changing times and the government's recognition of those changes. And secondly, and perhaps more importantly for those who practice law, there's a great number of provisions which are subject to employer-employee agreement, which is generally quite new with respect to the Employment Standards Act. And I wonder, and we'll wait to see the regs as to what exactly the requirements are, but I wonder whether that may cause us as solicitors to provide our clients with certain documentation wherein they could give that documentation to their employees for signature, and the employees would sign off on a number of things which are subject to agreement under the Act. So I throw that out as something to think about as I go through these different areas. That it may be that employees who previously would never see an employment contract may well see one now because of the requirements for employer-employee agreement under the Act. Now, on that note, I'll start with my first area, hours of work. Generally, the hours at work provisions require an 8-hour day and a 48-hour week as maximums. Now, the 8-hour day is subject to the qualification that if the workplace does not have an 8-hour day, then it is the regular work day of the workplace. So it's 8 and 48 unless the workplace has a different work day, in which case it could be more than 8. But 48 is the maximum for the week. Now, that said, there's an exception to that maximum where there's agreement between the parties. The employer can implement a 60-hour work week, and you may have heard of this. It was certainly the subject of a fair amount of discussion in the media, and it's something that no doubt we'll hear more about once the ESA 2000 is in place. But upon agreement between the employer and the employee, a 60-hour work week can be implemented, and that's the maximum, although that also is subject to certain kinds of industries which we'll perhaps see in regulation, which will be exempt from that 60-hour work week. Now, it's important to note that the agreement between the employer and the employee with respect to this 60-hour work week is revocable. The employee has to give 2 weeks that he or she does not wish to be bound by the agreement. The employer, for some reason, has to give, quote, reasonable notice. So it's unclear to me as to why there's a different standard for the two sides, but there is. Now, with respect to rest periods, this was certainly an area that the government was trumpeting as a benefit to workers, and I believe they were describing it as new mandatory rest periods. Specifically, it was 11 hours per day were going to be guaranteed rest periods. However, there's exceptions to that, including for on-call employees. There's also provision in the Act with respect to rest periods that requires 8 hours between shifts. However, that again is subject to exceptions. If over a 24-hour period, less than 13 hours are worked, then that 8-hour requirement is not applicable. And also, if the employer and the employee agree that 8-hour rest period is not applicable. Once again, agreements seem to trump a lot of the provisions in this Act. With respect to eating periods, after 5 hours of consecutive work, the employees are provided with an eating period of 30 minutes, or if there's agreement between the parties, the eating period can be split into 2 15-minute periods. So 1 30-minute period or 2 15s, but the employee definitely gets the 30 minutes total after 5 consecutive hours of work. Keep in mind that that period is unpaid, as it was under the, or as it is under the present Employment Standards Act. With respect to overtime, my second area, time and a half is to be paid after 44 hours per week. For certain industries, and again we'll see them set out in regulation, the 44-hour per week overtime requirement may not apply. I'll also mention to you that there are general provisions with respect to averaging and pay in lieu, and I'll give you a few more details about both of those. With respect to overtime averaging, if there's agreement between the parties, overtime can be averaged over a 4-week period for the purposes of paying overtime. So if the employer and the employee agree, the parties can decide that you look back for 4 weeks, average it out, and then pay overtime only with respect to those hours which are in excess of the overtime of the work week for the 4-week period. With respect to pay time in lieu, where there's agreement between the parties, the employer can provide 1.5 hours of work. Sorry, excuse me, I'm getting ahead of myself here. 1.5 hours of time off for every overtime hour. That has to be taken within 3 months of the time that the overtime was worked, or upon agreement, again, it's within 12 months of the time the overtime was worked. So upon an initial agreement to take time off, you can then enter into a further agreement that the time off is to be provided within 12 months of the time that the overtime was in fact worked. With respect to vacations, same as before, it's 2 weeks after 12 months, and vacation pay is 4% of earnings, and vacation must be taken within 10 months after the 12-month period in which the vacation is earned. So that's the same as it is now. Now there's new provisions. If there's agreement between the parties, vacation can be taken in increments of less than 1 week. Now that may come to you as no surprise, as perhaps those of us who advise clients and those of us who administer in the HR area no doubt see that on a regular basis. But now it's been formalized. Employees can take vacation for less than a full week period. No surprise there. Vacation pay has to be paid in a lump sum. And there's an interesting provision that vacation pay has to be paid in the event that prior to the vacation is taken, that there is a lockout or strike. Now that's referred to in the present Act, but it's made much more clear in the ESA 2000. Finally, my last area, and perhaps the one that causes most of us to think of the summer, holidays, public holidays. There is an elimination of the probationary period, the 3-month period, which previously was in place with respect to entitlement to public holidays. That's gone. Employees are still required to have worked the day prior to and the day following a public holiday. That's with respect to their regularly scheduled days. Under the ESA 2000, there's a requirement to work all of each of those days. So if the employee leaves for a reason which is not reasonable under the new Act, then the employee is disentitled to pay for that public holiday. And finally, there's an interesting change with respect to the calculation of holiday pay. Previously, holiday pay was to be paid as regular wages. One would have to pay the regular rate. Now there's a new formula which for some reason makes it a little more complicated. The formula is the total wages and vacation pay payable for the 4 weeks prior to the public holiday, and that's divided by 20. So for those of us who advise on these things, it's one of those areas where in fact the new provisions are more complicated than the old. So in a nutshell, that's hours of work, overtime, vacation, and public holidays. And unfortunately, as it'll take me at least a minute to get off this stage, I'm going to wrap it up at this point. Thanks very much.
Thank you very much, Jonathan. You did a fabulous job of pinch hitting, and we appreciated your insightful comments. Most instructive, of course, was the comment that the government, like some of my partners when they face deadlines, sees it not as a deadline but a guideline. And it sounds like not a lot's going to happen this August. For those of you who arrived recently, there are seats up at the front here. I noticed there's some people standing at the back. But our next speaker, many of you will probably know her as Melanie Pinchot. But thanks to my good friend Gord, who is also a top-notch reputation as an employment lawyer, she's now Melanie Manning. And that's a dynamic duo. But enough about Gord. I've known Melanie for about 5 years. She practices in association with Janice Rubin and Deborah Connell, and is a prolific speaker, writer, teacher. And she's about to give birth to her first book later this year called Pregnancy, the Workplace, and the Law, a Canada Law Book publication. And she's going to give us her thoughts on pregnancy and emergency leave. Melanie?
Thanks, Randy. Hopefully that book will come out. They keep changing all the laws on me, and I have to keep rewriting this book over and over again, but hopefully it will be out in the fall. This morning I'd like to talk to you about 3 of the main changes to the pregnancy and parental leave provisions of the Employment Standards Act as a result of Bill 147. The first change I'll talk about is to the length of the parental leave of absence. The second will be about the addition of a new leave and what has been referred to by many as emergency leave. And the third topic will be about the rights of employees both during and after the leaves. The extension of the parental leave of absence provisions across the country have come about as a direct result of the federal government's extension of the employment insurance parental benefits. The federal government determines the length of EI benefits, including those received by parents during or upon the birth or the adoption of a child. The length of a leave of absence that an employee receives to take care of that child and to still then have their job once they return to work is determined by the provincial legislation across the country, except for those employees who are in federally regulated industries such as banking or telecommunications. They turn to the Canada Labour Code. So just to make sure that everyone's clear on this point, the federal government determines EI benefits and the length of those benefits, and it's the provincial governments that determine the length of the leave of absence from the job. That is a point that has been misunderstood by many, and especially you'll hear that from your clients. People tended to think that these were one and the same thing, but in fact they're two separate things. So let's first start with the changes to the parental leave of absence. As you can imagine, pregnancy leave is available only to pregnant employees, but parental leave is available to both employees who are pregnant and to the fathers of the children, and also to adoptive parents. Previously, a pregnant employee who took pregnancy leave and a parental leave was entitled to a total of 35 weeks leave from their position. This was comprised of 17 weeks of pregnancy leave and 18 weeks of parental leave. While on the leave, the employee could collect employment insurance benefits, and that was comprised of 15 weeks of pregnancy benefits and 10 weeks of parental benefits, for a total of 25 weeks. As a result, the employee could be on leave for 10 weeks longer than they were receiving benefits, and it was their choice whether they decided to continue on the leave on an unpaid basis. It is open to employers still to supplement those benefits, and so in some cases employees could receive supplementary benefits during that time period. As of December 31st, 2000, the federal government extended the EI parental benefits to employees, and it increased from those 10 weeks to up to 35 weeks. You may be wondering why they chose December 31st. December 31st was a Sunday, and EI benefits always start on a Sunday, so they used that date rather than January 1st, the start of the new year. So with the 35 weeks of parental benefits, an employee who also received the 15 weeks of pregnancy benefits could receive benefits of 50 weeks, and after a 2-week waiting period could be away from work receiving benefits for a total of a year. This then put pressure on the provincial governments across the country to bring their parental benefits, parental leave, in line with the length of the EI benefits. If parental leave had not been extended in Ontario, at this point you would then see an employee who could receive benefits for 52 weeks, but would only have their job protected and be entitled to a leave for 35 weeks. And so the gap then turned around the other way. Ontario is among many of the provinces who extended their parental leave just before the end of December. And as I believe it was Matt who was saying earlier, a number of these, the Ontario changes went through just before the end of the year, and that happened with many of the provinces. And in fact, some of them passed them in the new year, retroactive to December 31st. So therefore, in Ontario, the former 18-week parental leave was extended to the following. If the employee had taken a 17-week pregnancy leave, she would be entitled to a 35-week parental leave as well, giving her a total of 52 weeks leave from work. If the employee was not entitled to the pregnancy leave, so a father or an adoptive parent, that employee would be entitled to a 37-week parental leave, which would then allow all those employees to take full advantage of the EI benefits available to them. I'd like to point out, as it has been said somewhat this morning, that this is the only part of the Act that actually is in force right now. And this was done through a transitional provision, Section 143, if you're happy to look it up. And it's the only part that's changed. So if you're looking for something that you can talk to your clients about now, this would be the only part. It should also be noted that an employee who is entitled to this extended parental leave doesn't have to provide any further notice to their employer that they're planning to take the extended leave. So for example, if you had an employee, or one of your clients is calling you about an employee, who gave notice that they were going to take this leave, let's say early in December, and then went on leave mid-December, prior to the changes that came about and were in effect December 31st, to determine whether or not that employee is in fact entitled to the longer leave, you have to look at the date that the person gave birth to their child. So if the child was born on December 31st or later, that employee is entitled to the longer leave, whether or not they actually started their leave earlier. Same thing, if you had an employee who did give birth prior to December 31st, but the child did not come into their care and custody until after December 31st, let's say after a hospital stay, that employee would still be entitled to the longer leave. That employee is not required to give notice to their employer that they're going to take a longer leave. That's automatic, and so if you have clients asking you about this, you should remind them that if they're planning to replace that employee while they're on leave, they should ensure that they are covering that person's position for the whole 12-month period, not just the 6 months that they previously did. So we'll turn to the second part, the emergency leave that's come into place, or will be coming into place. The first point to note is that this only applies to employees where their employers have 50 or more employees at that time. So therefore, it only applies to the mid or the large-sized employers. This leave provides employees with 10 days of unpaid leave to deal with such things as their own personal injury, illness, or medical emergency, or the death, illness, injury, medical emergency, or other urgent matter involving a number of specified people that are set out in the Act. Now the people who are specified in the Act as people that the employee can take this time off for includes not only their immediate family, but their extended family. And when I mean extended family, this is an extreme position. We're talking, for example, it includes the employee being able to take time off to address the situation with their step-grandparent of their spouse. So if there is any family relationship there at all, you may want to check the Act before you tell someone that they can or cannot take time off for this. It's extremely broad, to say the least. The other question that has come up with this emergency leave is, what is going to be considered an illness, injury, or medical emergency? An illness that requires someone to take time off is going to be considered something very different from person to person. The same goes to what is meant by an urgent matter. We have no idea what is going to fall in place there. Only BC, Quebec, and now New Brunswick, who included a leave similar to this in their amendments at the end of the year, have something analogous to this type of leave. But I would say that their leaves are more like a family responsibility leave. They tend to deal with an employee taking time off to address the care, health, or education of a child. That goes in BC and Quebec. And in New Brunswick, they have extended that to a close family relationship. The definition of close family relationship is still quite broad in New Brunswick, but certainly not as broad as it is under the Ontario legislation. So it may be that the interpretation of the family responsibility leave in each of those provinces will be of some assistance, but maybe of somewhat limited assistance given the differences in the focus of the leave itself. The third point that we'll turn to is the rights of employees both during and after leaves. Generally, there has been little change to those rights for employees on pregnancy and parental leave. However, under this Act now, these rights will also apply to employees who are on an emergency leave. So one of the rights is that employees may continue to participate in their employee benefit plans, such as their pension plans or their extended health and dental plans. Employers must continue to make contributions to those plans while a person's on leave, and now that also applies to individuals on an emergency leave. Now obviously that's only for a maximum of 10 days, so a starting and stopping of that is probably too difficult administratively. The other change is that the employee's length of service, length of employment, or seniority will also include the time that a person is on emergency leave, just as it is included for those on pregnancy and parental leave. The only exception to this is that time's not included when you're calculating whether or not the person has passed a probationary period. An additional right or a so-called right that an employee has is that they have the right to be reinstated to the position that they held prior to the leave, or to a comparable position if that position no longer exists. The new Employment Standards Act does provide an exception that we haven't seen specified before, and that is where the employment is ended solely for reasons unrelated to the leave. Although we'll have to wait to see how this exemption will be interpreted, it may clear up a long debate about whether or not reinstatement creates a mandatory obligation to return the employee to a position in the company, even in the face of a restructuring or misconduct on the part of the employee that would amount to cause. So that may clear up that issue, although we'll have to see what that entirely means. So I think there are 5 main points that you can take away with you today. The first would be that it is the federal government that deals with employment insurance benefits, while it is the provincial government that determines the length of a pregnancy or parental leave. The second would be that the extension of parental leave in Ontario is the only substantive change to the ESA that has effect right now. The third would be that a pregnant employee taking both pregnancy and parental leave may take a total of 52 weeks leave. Fathers and adoptive parents may take 37 weeks of parental leave. Fourth, there will be 10 days of unpaid emergency leave available to employees to deal with their own illness, injury, or medical emergency, or the death, illness, injury, medical emergency of or some other urgent matter of a member of their extremely broad extended family. And fifth, that the rights of employees who take leave will apply to those taking emergency leave as well. Thank you.
While Randy is coming up to introduce our next speaker, I just want to underline that point that Melanie made about the changes on the reinstatement provisions. The specific provision that's been added says that you do not have to reinstate, or it's an exception to the reinstatement obligation where the dismissal is solely unrelated to the maternity or parental or emergency leave. That language is important because for years there had been a big debate over whether or not the reinstatement provisions created a form of super job security for people on mat or parental leave. And without much fanfare, certainly not as much fanfare as some of the other new provisions received, the government slipped in this language which arguably takes the side of those who have said that people shouldn't have super job security when they're on maternity or parental leave, and I think it's going to spawn a lot of new litigation, which I think, anyways, will be quite interesting.
Our next speaker has the invidious distinction of standing between you and the coffee break at this morning. Barry Fisher is known to you all as the wrongful dismissal database guy. He's been a member of the bar now. I think you're heading into your 3rd decade, but you'll also know that he's a very active mediator and arbitrator today, and I can speak very highly of his talents from a personal standpoint. I've used Barry quite a number of times, and one of my early adventures involved a case with an upcoming speaker, Howard Levitt, which went till 3 in the morning, but to Barry's credit, we settled. In fact, I don't think I've ever had a case that hasn't settled with Barry. He's also a very animated and outspoken speaker, and I guarantee you that in addition to the substance he's going to give you, he will give you at least one laugh per minute over the course of his speech. Barry, you're going to talk to us about termination wages, records, and postings.
Well, I have to live up to that billing, so let me say first of all that the reason, with all this dynamic speaker comments and everything, and I'm the only speaker, I think, other than these two, because they organize it, that have spoken it each year. So my punishment was to speak on this topic, which is the most boring topic, because frankly, nothing changed. So I'm going to take you through the minute changes that took place in the ESA 2000 on these sections. The first, and in a world of boring changes, one of the more interesting ones is this posting requirement. It's sort of innocuous. It's basically a general requirement for all employers to post in the workplace whatever the ministry tells you you have to post. And of course we don't know what that posting is going to look like. I assume it's going to be similar to the WSIB thing that you put over the washroom. If you have an accident, you got to file all these reports and everything. But it does raise some interesting issues. A, as to what they're going to put in that posting. It's probably just given, it may just be a list of employer rights, you know, given the present ministry. So you're going to have a workplace now which has what happens in case of an accident, under the Labor Relations Act, how to decertify that union that happens to be here, and another list perhaps of employer rights, all in the name of employee rights. It'll be interesting to see what happens if there's something in the notice and the employee doesn't post it. So the one I'm thinking about is we still have that vicious 6-month limitation period, eh? In the Act, they haven't changed that. I'm looking to Mr. Parry. I only read this section. I really had to. So, and I suspect a lot of employees don't realize it's a 6-month limitation period. It'll be fascinating, for instance, if the notice that the employer had to post mentioned the 6-month limitation period, which would seem fair, right? And then an employer doesn't post it. Could you argue that that employer cannot rely on the limitation period because they didn't post it? I don't know. I had to make up questions because this section is so boring. And then there's another issue, too, of what do you do where there's no actually established workplace? Presumably, you know, people working out of their home, that sort of stuff. Presumably you get away with that by enclosing a once a year or something in their paycheck. But it does presuppose a workplace, and a lot of people in today's e-commerce world and all that really don't have them. Okay, that's really about it on that part of the posting. The other aspect is, and this I only found by really digging, was there was a difference in Section 93, which is an employment standards power of the officer type clause, where he now has the right to post a copy or part of all of a report made by an employment standards officer made against that employer. So for instance, and this one's interesting, this is always the one that raises fear in the employer's hearts. Not that they get called in to look at some stupid overtime claim that maybe costs them a couple $1,000, but that God forbid they've been doing this for all 5,000 employees of that employer. Now, apparently, the employment standards people are going to be could require the employer to post in the workplace that case that they lost, or even parts of the case. So that might raise an interesting issue as to, may raise another reason why employers want to comply with the Act, because their losses will be posted beside all those other notices that I've mentioned. Okay, on deduction, on wages, very little difference there. They now allow direct deposit. Wow. But there actually was a case, I think it was in British Columbia, where a guy filed a complaint under the Employment Standards Act because he wasn't getting a check. And it went all the way, I don't know how far it went, and it was upheld. It said, no, you had to pay by check, and the employer was forced to cut a check for this guy or something, and it was bizarre. So now direct deposit, and there are rules on direct deposit about having it close to the employer. You know, you can't sort of set up the check in the bank of whatever, Yellowknife or something like that. Would be a useful way of avoiding your people having access to their paychecks. On the deduction from wages section, you know that lovely part where the employer just applies the right of set-off however he feels like it? I'd love to know the rhyme or reason behind this, because they've taken some stuff that was in the Act and moved it to the regs, and then they've taken some stuff that was in the regs and moved it to the Act. Would have been nice, actually, if more of it was in the Act so you could actually read it. This is one of those ones that they've actually moved to the Act from, it used to be sort of in the Act, but the guts were in the regs. Now it's all, from what I can tell at least, all sort of in the Act. And I'm not now the only interesting change there, or the only change, I'll let you decide if it's interesting, is that the old Act talked about there being liquidated or unliquidated damages. One of those, you know, re ipsa loquitur Latin thingies that nobody understood. Now they talk about the employee authorization has to refer to a specific amount or a formula for which a specific amount may be calculated. A lot of these cases have to do with, at least especially under the federal code, truck drivers who damage cars and the employer tries to get it back and everything. So this one, it raises interesting issues as to whether you could even have an authorization before the fact, since it has to refer to a specific amount. On the other hand, it references a formula. So I'm wondering if the formula could be as easy as follows. This would be in a guy smashing up the employer car thing. Money owing equals amount paid to body shop. Which would sort of get around, I suppose, the formula approach. Okay, statement of wages. Actually, you know, as an aside, this paper forced me to actually read these sections, even of the old Act that I'm not sure I ever really read. And this is, although it's boring and technical, it actually can be very useful. These recording sections, for instance, this is the obligation of an employer to record hours. I don't know how many times in an overtime case where I represented the employee, who inevitably kept their records on the wall calendar in their bathroom or on napkins or whatever, or they made it up just before they handed it in, who knows. Those would have been Certosimo's clients. And the employer has nothing. And the employer's attacking the validity of the employee's records. Well, too bad, employer, you're supposed to keep the records. And therefore, that's one of the reasons the employment standards guys would normally accept almost any piece of junk from the employee, because the employer was in violation of the Act. Well, now, the employer, if a person is a salaried employee, where's my section here? If the person is a salaried employee, am I jumping ahead here? Sorry, hold on. Statement of, okay, sorry, I wanted to talk about statement of vacation pay. Section 1 or 12(1)(c) and 36(3), here's a combination, now allow an employee to take his vacation pay in every paycheck as long as the employee consents. Previously, to do this, you needed the approval of the director, so you don't need that anymore. You have to, however, give wage information to the employee in electronic format also if you're going to pay him in electronic format. 5 minutes left, I'm being told. Okay, well. Yes, here we are on the records one. I'm sorry, this is on page 5-10. There used to be an exemption for, you had to keep pay actual start and finish times for everybody except clerical employees. I don't know why they had that exemption, but anyways. Now you only have to keep record of excess hours for salaried employees who are subject to the provisions of the overtime, and you don't have to keep any records, of course, for people who get overtime. What I always used to tell my employer clients, especially on these excess hour ones, is the best way to ensure compliance, especially on this excess where you don't really know where the person's doing it, is to put the onus on the employee to keep the record. So you say you have a policy which has all that usual gumph about being pre-authorized, which is completely unenforceable anyways, but you make it so that the employee hands you in a timesheet every week specifying their overtime. If the onus is on the employee to do that, and they choose not to because, of course, the boss frowns and doesn't like receiving those memos, then I think you have a really good case to say the employee who 6 months later pulls out their little wall calendar saying, hey, we asked you to hand in your report every week. You handed it in, it showed no overtime. We've satisfied our obligation under the Act and we don't owe you anything. Okay, termination and severance pay. An absolutely critical component of the whole Act, but very little has changed. And all I've done really is printed off the new section, so when you're throwing around new numbers, you sound like you actually read the Act. But I will go over with you the few small changes. The exemptions to both termination and severance pay are now going to be found only in the regs. Under the old rules, they were sort of half in the regs and half not, so we don't know what, if anything's going to change there. Termination pay now recognizes constructive dismissal as a termination. Everybody knew it did before, but it wasn't so explicit. Severance pay said constructives, termination pay didn't. Now they both say it. They moved the temporary layoff section into the Act as opposed to the regulations. Again, one of those little changes that doesn't make a lot of sense. And here's an interesting one. In the old rules, and if you read Bob Parry's book, to have a definite layoff, like if you tried to do that 13-week thingy or drag it out to 35, then you had to give a definite date of recall, and that was usually a trap for the employer who thought that one up later. You'd look at the ROE, it would have no date of recall. You look at the layoff letter with no date of recall. Now they've amended that, I guess, to make it easier for employers. And now a temporary layoff doesn't become a permanent layoff. It's not a deemed termination unless the employee is laid off for longer than the temporary period allows. This means that an employee who's given a notice of layoff, unless it's a permanent layoff, virtually has to wait either 13 or in some cases 35 weeks before they can sue, which is unfortunate because the whole tactic there is, of course, drag the guy out and hopefully he'll get another job because he's getting no pay during that period and questionable whether they can sue for it. And most people then get another job and then the employer magically issues a recall notice only when the person gets a new job. Again, under the 1 minute left. Okay, I'm going to make it's the first time I'm ever going to make my time frames here. Under the old Act, severance pay could only be paid in installments with the consent of the director. Now no director consent is required, but the employee consent is required. So one last comment, because I have like 45 seconds, and other speakers have spoken on this. I think a huge area is going to be this whole issue of consent. Is it going to be, are we going to have doctrines of informed consent? Does the employer have to bring to the attention the Act? Do they maybe have to talk about the regulations and the case law? I don't know. Are you going to have to give an opportunity for these individuals to presumably seek legal advice? Are they going to be able to retract consent? Obviously, if you have a client who was stupid enough to give such a consent, you're immediate, and then something happens to them at any time, you'll be able to allege reprisal. Or, no, sorry, if you refuse to give consent, that's what it is. The person refused to consent to something, and then something will change in their workplace, like get fired, then you'll have a reprisal section. So I think the real minefield for lawyers on this one is going to be the whole issue of consent, and we'll see if it takes on sort of, well, the worker's signature is on there, so it must be good, or are we going to almost be into a doctor-informed consent type issue? Thank you very much.
It's Monday morning. We intended this opening session to provide you with a briefing on the new ESA 2000, but as we approach the break, we should fill up with some coffee because we're about to change gears dramatically and move into the 6-minute format. So at 10:35, we'll reconvene and we'll move into the 6-minute presentations. Thank you very much. If it looks smells, and tastes like tomato juice. Remember that from Laugh-In? If it looks, tastes, and smells like tomato juice, Norm over here, Norm Grosman over here is saying, no, I don't remember Laugh-In. Sure you do, Norm. You're too young. At this point, the tomato juice would fly out from behind the door all over Norm if we were on Laugh-In. If it looks, tastes, and smells like tomato juice, it must be tomato juice, right? Well, that's the underlying premise for the next topic on independent contractors. We've all faced that question either on behalf of the independent contractor / employee or on behalf of the contractor / employer. Is this person who we haven't been withholding taxes from really an employee? And of course the answer is yes, after they've been fired, because they want damages, right? Or they want protection of the Employment Standards Act, and they want to be within the definition of employee in the Act, which, as you all know, is broader than the common law concept. In any case, David Hager is an excellent person to have speaking on this topic. He's had occasion to litigate such matters, I believe, before the federal court in the tax context, but employment context too. David's the chair of the Lang-Michener Employment Law Group. He's got 20 years of experience. His practice is in labor and employment law. And I know he likes the title of the presentation that I suggested, because he called over to see which case it was that I stole the line from, and I assured him it wasn't a Laskin decision, it was in fact Laugh-In. So please welcome David Hager.
Good morning. The continuum is upon us. We as council can no longer analyze the relationship of employee-independent contractor as if it existed in two separate boxes, with the employee in box A being entitled to reasonable notice and the independent contractor in box B being entitled to no notice. It is clear from recent cases that we should examine the relationships as if they exist on a continuum, with the employee relationship being on one extremity and the independent contractor or special agency relationship requiring no notice to be on the other extremity. In between, we must examine the facts and determine whether the relationship bears more resemblance to an independent contractor or to an employee. To the extent that the relationship is more akin to that of an employee, recent cases tell us that the relationship will fall within an intermediate category which requires termination upon reasonable notice. The paper itself, I just want to make at one point, I'd like to acknowledge Ken Krupat, who assisted me in the paper, and I know Ken is here today somewhere. It's over there. 3 cases in the paper: Marbury versus Abercan, a British Columbia Court of Appeal decision, and last year's 2 Ontario Superior Court decisions of Job and Remax and Regal Producers and Fowler, all found the intermediate relationship which required reasonable notice of termination. And the courts, in looking at the factors deciding where on the continuum the case should reside, look primarily at the factors of the permanency of the relationship, the duration of the relationship, the degree of reliance between the parties to the relationship, and then the degree of exclusivity. The longer the relationship, the greater the permanence, the greater the exclusivity, and the greater the reliance, the relationship moves along this continuum until it reaches a point where it is more akin to an employee relationship. Now, that of course still leaves us with uncertainty, but that's great for litigation, and my income normally goes up directly in proportion to the uncertainty. The courts have given us a number of factors in addition for us to consider. Number 1, the fact that a corporation is used is of no consequence in determining the status. Both Marbury and the Regal decisions both concerned corporations which were successful. Secondly, we all know that it is an immutable law of physics that one cannot suck and blow at the same time. But in fact, in this area of the law, that is precisely what a plaintiff can do. There are two decisions, Brown versus Western Legal Publications and the British Columbia Court of Appeal decision in Trong versus British Columbia. In each case, the plaintiffs they declared themselves to be independent contractors on their income tax returns. No deductions were made for income tax, CPP, or EI. In both cases, the plaintiffs were found to be employees, and the courts clearly stated that the plaintiff can claim to be an independent contractor for purposes of the Income Tax Act, but at the same time can claim to be an employee for wrongful dismissal purposes. So there goes some good arguments from defense counsel when you look at the income tax returns. Of course, one issue that arises is, will the plaintiff be entitled to the same notice or less notice if the relationship is found to be one that is akin to, but not that of an employment relationship? The cases are unclear. They go both ways. The Marbury and the Job decisions were based upon factors such as length of the relationship, the exclusivity of the relationship, the time required to reestablish themselves. And in Marbury, we had a 10-year relationship which accounted for 90% of business, and that netted the plaintiff a 9-month notice period. Job dealt with a RE/MAX real estate salesman who had a 6-year exclusive relationship with RE/MAX and took some time to become reestablished with another broker. That led to a 6-month notice period. Now, those two results are not all that dissimilar from what one might expect if you used the traditional Bardolph factors in an employment situation. But because the factors are different, there's going to be scope for different results. And in fact, in New Brunswick, there are 2 cases where the courts found the plaintiff to be in that intermediate category requiring reasonable notice. In each case, the court set out the notice that it would have found had the plaintiff been an employee. In fact, in the decision of Jackson and Norman Francis, the court said you would have received 18 months, but because you're in this intermediate relationship, you're only getting 9 months. So there's 2 cases that say the same thing. They're both by the same judge. The paper itself raises the issue of the use of written contracts in an effort to reduce the notice period required that by common law. You could look at that. I've raised an issue as to whether or not minimum standards of notice will be required, such as the McNamara and Hodge requirement for employment contracts. I've referred to Revenue Canada. Briefly, nothing has changed. We still have to pay taxes, and the Weebdor 4-in-1 test still applies. I think I've met my time.
As Matt indicated, we're going to step up the pace a bit. We promised to get you out of here at 12:43 as promised. So thank you, David, for bringing some clarity to what's a very difficult area. Our next speaker is Norman Grosman. Norman's a partner in the Grosman & Gale law firm, a leading employment law firm both in Toronto and Canada. He's a prolific writer. He's written federal employment law in Canada and a practical guide to the law of hiring in Ontario. But he can also be a very entertaining speaker. He may not give you a laugh a minute like Fisher, but I chaired a symposium a little while ago where he started off with a Groucho Marx video. That certainly caught the attention of the crowd. I don't know what's up Norman's sleeve, but he's here to talk to us about legal issues arising from recruitment agencies.
Thanks, Randy. No videos this morning, unfortunately, due to time restrictions. I want to use 30 seconds of my time to thank Randy and Matt for inviting me to speak at the conference today. This is my 3rd out of 4 6-minute employment lawyer conferences, so I've done 18 out of a possible 24 minutes, and I think that's a pretty good record in any arena. The topic, the challenging topic, I should say, that I was assigned this year is headhunter or headache, legal issues arising out of the use of recruitment agencies. I want to have you imagine for a moment that I'm standing between Randy and Matt and using them as props. If you remember the game we used to play as kids called Broken Telephone, where Matt would tell me a story and then I'd pass the story on to Randy, and Randy might go away for a few minutes and then relate the story to me, and then I'd tell it again to Matt, and we'd have a good laugh over how twisted the story had become in the process. If you change a few of the basic premises of that game and say for the moment, number one, that we're now all adults in the working world, two, that Randy is now an employer and has a personnel need and is willing to pay me a whack of money if the story that I pass along to Matt sounds good to Matt. Three, that Matt, on the other hand, wants a job and is not only very interested in the story that Randy tells to me and I pass along to Matt, but is also prepared to embellish his story if he thinks it will help me to tell Randy what he wants to hear. The one thing which stays static is I'm the middleman in that game and in that process. And in an adult world, I'm called a headhunter or a recruiter, or if enough money is involved, I am part of an executive search organization. But the game is still fundamentally the same as it was when we were kids, except that we all now have a much greater incentive to spin the story that we tell because we all want something out of the game, not just a laugh anymore. Randy wants the best candidate available in the marketplace, Matt wants the best employer and the best job in the market, and I want to make a fee. At the risk of sounding somewhat more cynical than I intend to be about recruiters, that is the game of recruiting. Now, some of you may have already guessed or may be aware the legal term for the game of broken telephone is misrepresentation. It comes in three flavors: innocent, negligent, and fraudulent. It's pretty rare to find a recruiter who is so unscrupulous that he or she will fall into the category of making fraudulent misrepresentations, but it's not that remarkable to find negligent or innocent ones. I think that recruiters play a very useful role in connecting candidates with potential employers, but they should not be used as a substitute for either party abdicating its responsibility to determine if it's the right fit and the terms that will govern the particular relationship. In the Kilpatrick and Peterborough Civic Hospital case, which was reversed on for other reasons at the Court of Appeal, Mr. Justice Wilkins talked about the relationship between recruiter and employer. And in that case, the recruiter was named McMonigal and the candidate or employee was Kilpatrick. And he said whether or not McMonigal had any authority of the board of directors is of no instance. During the negotiations, he acted as agent for the hospital, and any representations he made leading to reasonable inferences to be drawn by Kilpatrick, the candidate, would have been binding on the hospital. And I don't think that's a particularly remarkable finding that the judge holds the recruiter responsible for the representations that it made on behalf of Randy. So what can Randy do to protect himself as the employer? I suggest that he can provide me, the recruiter, with a written mandate as to what his requirements and expectations will be and the general terms and conditions that he's prepared to offer the candidate, and require that I stay within that mandate. Second, he should meet with the candidate and discuss all of his expectations and the rewards associated with the position and not abdicate his role as potential employer. And finally, and perhaps most importantly, what Randy can do as an employer to protect himself is have a comprehensive written contract with Matt, the employee, which spells out the essential terms and conditions of the relationship, and most importantly, has some sort of entire agreement clause in the agreement that says essentially what you see here in the contract is all of the promises and representations that have been made, oral or otherwise, whether by me or my agent, the recruiter. What can Matt do to protect himself in this curious relationship? First of all, as a candidate, he should insist on having as much direct contact with Randy, the employer, as possible, and be wary of me if I am blocking his access to Randy. That should be a red flag that perhaps I am spinning the story a little too heavily in the direction that he may like to hear it. He should test the representations and promises and assertions that sound too good to be true whether they're made by me or directly by Randy. And finally, he should try and get the terms and conditions in writing as a further act of due diligence in crafting his relationship. I think the bottom line in terms of avoiding headaches with recruiters is a contractual solution. If the parties ultimately, despite the dance they go through in the recruiting process, ultimately cut me out of the action, and the representations, or perhaps more importantly, the misrepresentations I may have made, if they cut those out of the action by virtue of ultimately settling on a contractual relationship, they are much more likely to end up happy with each other, to avoid miscommunication, and to avoid the legal headaches. That's it for today. No videotape. Stay tuned. Thanks.
Cheryl Elliot was one of the most highly rated speakers at last year's 6-Minute Employment Lawyer, and so we asked her if she'd come back again this year. She's a partner at Baker McKenzie. She practices in employment and labor law. She's the author of texts such as the Ontario's Equity Laws and co-author of Sexual Harassment on the Job, and she's here to answer the question, I hope: is there really any such thing as probationary employment at common law?
Thanks very much, Matt. Matt's promised that the 10 seconds it takes my IT guy to set up my computer for me don't count on my 6 minutes. Let's hope he keeps his word. Otherwise, I have to tell you all that I did win the speaking contest at my summer camp several years in a row, so I'm hoping I can do the same thing here today. If you've never done this conference and spoke in 6 minutes, I got to tell you it's a real challenge. Okay, here's the stopwatch. Let's see what we can do. Most employers do use some form of probationary employment for new hires, and it's often set as 3 months. In many cases, because the employer believes that the Employment Standards Act authorizes that period of time as a probationary period, since the employer is not required to provide notice or pay in lieu until after the 3 months. This is interpreted as statutory authority for a 3-month period. It's not surprising, really, when you consider the traditional view of probationary employment. It was seen as a form of a fixed-term contract, and if not hired at the end, the employee had no wrongful dismissal claim. And during the probationary period, the employee could be dismissed at any time without cause and without notice. Today I'm going to speak very briefly on 3 issues. The first is, what is a probationary employee? The second is, what standards apply to their termination? The next is, are those standards so similar to those which apply to quote-unquote permanent employees that there really is no distinction between probationary and permanent employees? With respect to the definition of probationary period or employee, there appears to be a broad consensus on that point. Essentially, it's a period during which the employee is tested to ensure that they're suitable for permanent employment. Typically, employers set 3 to 6 months as a probationary period. Traditionally, an employer had an almost unfettered discretion to dismiss as it saw fit during the probationary period. For example, in Markey and Port Weller Dry Docks, the plaintiff was terminated 27.5 days into a 30-day probationary period, primarily for performance reasons. He had, among other things, refused to take any further instructions from a senior foreman until they were put in writing, and suggested that if he and his own foreman were examined by a psychiatrist, he would come out the better. His employer was not amused, and he was summarily dismissed. The court concluded that because he was a probationary employee, his employer could dismiss without notice and without cause. The only restriction was that there could be no improper reason. So, for example, discrimination under the Human Rights Code or union activities would be an improper reason which would have barred that termination. In a 1979 decision, Nicholson and Haldeman, Norfolk, the Supreme Court of Canada decided that a probationary employee could not be dismissed at the board's pleasure. Even though this case involved a public sector employee and an administrative tribunal, and is therefore obviously different from a private sector employee-employee relationship, Nicholson paved the way for the development of the common law applicable to the private sector, i.e., that probationary employees are entitled to be treated fairly on termination. The first private sector case to import this duty was Ritchie and Intercontinental Packers. Ritchie was terminated 5 months into a 6-month probationary period, allegedly because of a reorganization. In fact, he was terminated because of various performance issues during his tenure as manager of human resources at a unionized workplace, primarily because he had created friction with the union. And as we all know from working in unionized settings, the HR manager who does that is definitely on the way out. The judgment notes that the trend in this area was away from an unfettered discretion toward fairness, and concluded that an employer must act fairly and with reasonable diligence in determining whether the employee is suitable. Factors the employer could consider included the employee's ability to meet the employer's standards, testing of skills, ability to work in harmony with others, future usefulness, and other factors that the employer deemed essential to performance. Also on this trend, Buckle and Mother Parker's Foods, where the court held that even if an employer is not required to have just cause in terminating a probationary employee, it was at least required to justify the manner in which the decision to terminate was effected and the basis for the decision. Misen and Bank of Nova Scotia traces the evolution of the treatment of probationary employees from the original harsh doctrine to an attitude of greater fairness. The onus is on the employer, and the judgment cites Kirby and Motor Coach Industries to the effect that just cause for a probationary employee can be simple unsuitability, including such things as character, etc. This is, of course, subject to the employer's obligation to act fairly and bona fide. Finally, more recently in Maguna, Justice Malloy held that when dealing with a probationary employee, an employer is still required to show just cause, but there's a lower standard as to what will constitute cause. For example, simply not suitable, not compatible with the nature of the workplace or the co-workers. And again, this is subject to the bona fide requirement. So in conclusion, even if an employer is terminating a probationary employee, it must justify that termination. And if no cause, it must give notice. But cause is judged differently for probationary employees than it is for permanent employees. And it will include such things as failure to meet the employer's standards of conduct, incompatibility with the culture or the nature of the workplace, inability to meet production standards, and overall unsuitability. So the answer to the question, is there such thing as a probationary employee at common law, is a qualified yes. Qualified because while employers no longer have an unfettered discretion to terminate, the standard for cause is not as stringent as that for a permanent employee. And I'm here, and I made it in my time. Thank you.
Thank you, Cheryl. You can tell she's been here before. You did a great job of packing 3 cases into 6 minutes. Our next speaker, Joe Conforti, is a leader of the employment practice at Goodman's LLP. In his opening remarks, Mr. Justice Laskin mentioned the Lyons and Multari case, and Joe is going to canvass that for us and deal with non-competitive clauses in the wake of that case. Joe?
Thank you. First of all, you should know that the Lyons-Multari case is the last word, the most important word on the issue of non-competition, non-solicitation covenants. Leave to appeal to the Supreme Court of Canada was sought and was denied 2 weeks ago, approximately 2 weeks ago on May the 5th. In reviewing the restrictions in Lyons and Multari, you should consider and bear in mind there are really 3 types of restrictive covenants. First is a non-competition covenant, and that's the kind of a covenant preventing a departing employee from competing by joining the competition or establishing a competing business. Second is non-solicitation, and that's the type of covenant that would prevent the employee from soliciting certain clients or employees. And the third type of restriction is confidentiality, and that means protecting proprietary information or confidential information, trade secrets, after termination of employment. The degree of enforceability depends on the type of restriction that you're considering. In Lyons and Multari, the Court of Appeal was faced with the enforceability of a non-competition covenant in the context of a professional employment relationship, and in that case it involved a dentist. The issue the court was faced with was fairly stark. Freedom of contract versus freedom of competition, allowing people to carry on the business that they're trained for. Simple review of the facts. In 1993, the defendant, Dr. Multeri, completed his specialization training. He wanted to practice dentistry. At the same time, the plaintiff, Dr. Multeri, was a dentist in Windsor and was looking for a new associate to work with him. Dr. Lyons hired Dr. Multeri, and they agreed on a handwritten contract, a simple contract less than a page long. The relevant provision was a non-competition covenant that, its entirety was 6 words, and even with abbreviations. It read, quote, protective covenant, 3 years, 5 miles. That's the entire covenant. The defendant, Dr. Multeri, worked for Dr. Lyons for about 1.5 years. He gave notice after a while. He was quite successful. He started off earning a couple $100,000 a year. He competed within 6 months of leaving, within 3.5 miles of his former office. Dr. Lyons started a lawsuit. Trial judgment comes down. After a 5-day trial, trial judge determines there's a breach of contract, awarded damages of $70,000. There's an appeal. It was accepted as a fact that the non-competition covenant was clear on its face, and Dr. Multeri understood the meaning and effect. In fact, the trial judge said that the clause was, quote, elegant in its simplicity. And in passing, I'd note that I'm going to take that to heart, and I will shorten my long covenants, if that's all it takes. The appeal was limited to whether the non-competition covenant was valid. According to the Court of Appeal, there's a 3-fold test to be applied to determine whether any restriction in an employment contract is valid. First, does the employer have a proprietary interest that is entitled to protection? Secondly, is the time and geographic scope of the contract too broad, or is it reasonable? And third, is the covenant unenforceable as being against competition generally, a version of being against public policy? On the issue of proprietary interest, the Court of Appeal answered yes. There is a proprietary interest in this case. It's well established in the case law that employers have a proprietary interest in their client base. In this particular case, Dr. Lyons' practice was one that was a referral type of practice. A core group of dentists customarily referred to Dr. Lyons' office, and that constituted goodwill. Goodwill qualifies as a legitimate proprietary interest that ought to be protected. So test 1 is passed. Second test, temporal and spatial limits. The court said this was fine. 3 years, 5 miles is reasonable for even professionals. Surprisingly, for an employment case, in my view, 3 years was determined to be reasonable. I had relied on many cases that had 2 years as being the reasonable maximum that was allowed, but the Court of Appeal did refer to a Supreme Court of Canada case that permitted a 5-year restriction. The key test, though, and what the Court of Appeal based its decision to say that this contract was unenforceable was that it was against competition in general. Where a non-solicitation covenant could apply and could protect the employer's interests, then you ought not have a general non-competition covenant. A non-competition covenant is an exceptional remedy, and that's less than a minute. So I'm going to finish up anyway.
Take it to appeal.
So the Court of Appeal said the contract was unenforceable, no damages would be allowed, overturned the trial judgment, obviously. What you can take from the decision: for professional employees, non-competition covenants will rarely, if ever, be given. This was a trial decision. Remember, at an interlocutory injunction stage where most of these type of cases get litigated. You have to meet a much higher test, convince the court that there's a prima facie or at least a serious question to be heard. If it is unenforceable at trial, it will be very, very difficult where a non-solicitation covenant could be used to have an injunction for a departing employee. Third thing to take from this case, dentists in Windsor make $200,000 to start. And the fourth thing to take from the case is that one ought to not overreach when drafting a contract, unlike any other commercial contract where lawyers try to get the best for their client. In this type of case, if you reach too far and you're successful in convincing the other lawyer or the other party to give you what you want, you will end up being worse off. In this case, Dr. Lyons, by getting a general non-competition, was left not only with an unenforceable non-competition, but he didn't have a non-solicitation covenant, and that's something to bear in mind in drafting contracts. Thank you.
Geri Sanson is a partner at the firm of Sanson and Hart, a firm dedicated to human rights and employment law, and investigation, facilitation, mediation, and adjudication of harassment and discrimination complaints. But most impressively, Geri recently received the Law Society Medal for her work in the area of equality rights, which was awarded in recognition of her outstanding service in accordance with the highest ideals of our profession. Geri was also counsel in the Pritchard case, and as a result, we thought there could be no better person than Geri to invite to speak on the broad topic of dealing with the Human Rights Commission, but specifically on the impact of Pritchard. Geri Sanson.
My paper is found at tab 10, and it explores the Pritchard decision in detail. I note leave to appeal was refused. It examines other human rights and employment law cases where dealing with severance packages, settlements, or releases, which have not resulted in barring individuals from pursuit of their claims, and that's at pages 7 through 12. It examines the role of the Commission and its failure to adequately deal with complaints of sexual harassment. And I come by my comments honestly, as I used to be counsel to the Commission. And it concludes with some comments about what Pritchard means for practitioners. In addition to the Pritchard decisions, you'll find a copy of the Vince inquest recommendations dealing with sexual harassment. Teresa Vince was a 25-year Sears employee who was shot to death by her boss in the Sears store in Chatham after allegedly experiencing a lengthy period of sexual harassment and stalking. Ironically, Colleen Pritchard was fired by Sears just 1 month after Teresa Vince was shot to death. And the Commission dismissed important aspects of Colleen Pritchard's complaint immediately following the Vince inquest jury's recommendations, many of those directed at the Commission towards improving the way it should deal with sexual harassment and other complaints. The Commission was a party to that inquest. The Pritchard case is the first articulation by the courts on the proper interpretation of bad faith, pursuant to Section 34(1)B of the Code. Colleen Pritchard's complaint alleges she was the victim of sex discrimination, stalking, and sexual harassment, and reprisal for having pursued an earlier sexual harassment complaint. Ms. Pritchard alleges these actions resulted in her dismissal from employment and a failure to rehire by Sears. At the time of the dismissal, Ms. Pritchard was offered little more than payments of sums to which she was entitled under the Employment Standards Act. She was given 1 week to consider the offer. During that week, she contacted an employee from the Employment Standards Branch who advised her the release would not be binding. She also contacted a lawyer in Ottawa who asked Sears for further time to consider the offer. Sears refused to grant the extension required. On July 30th, 96, Colleen Pritchard signed the release. The release stated that she released claims including any entitlements under the Human Rights Code. It also indicated that she had sought independent legal advice or waived her right to same. In fact, Ms. Pritchard had not been given enough time to seek legal advice on the human rights aspects. When she filed her complaint, Sears requested the Commission not deal with it pursuant to Section 34. The Commission dismissed important aspects of her complaint as bad faith and refused to alter its original decision on reconsideration. The Divisional Court set aside both decisions and remitted the matter back to the Commission for proper consideration. Justice Swinton for the Court found that the Commission had improperly fettered its discretion. She stated that undoubtedly in some cases, an employee who accepts a sum of money in exchange for a release, including human rights claims, could be acting in bad faith in subsequently turning around and filing a complaint. However, in other cases, the facts may show the employee misunderstood the significance of the release, received little or no consideration beyond statutory entitlements, or was in such serious financial need that he or she felt there was no choice but to accept the package offered. To take the approach that there is bad faith whenever a human rights complaint is brought after signing a release risks ignoring the context within which a particular complaint was signed and denies access to the investigative procedures under the Code without assessing the complainant's individual moral blameworthiness in pursuing the complaint. Bad faith connotes moral blameworthiness on the part of the accused, encompassing conduct designed to mislead or be pursued for an improper motive. While much interest in this case has been on the question of whether a signed release constitutes evidence of bad faith, the Divisional Court also affirmed that the Commission has yet again wrongly restricted its powers on review of applications for reconsideration. This underscores a serious systemic concern with the restrictive approach taken by the Commission in the interpretation of complainants' rights over the last several years. What should be of serious alarm to human rights practitioners is the fact that in the Hall case back in 1997, the Divisional Court told the Commission that it was using the wrong test. That exact same test was used in Pritchard. This means that the Commission has been throwing out cases on the basis of the wrong test for at least a year and a half. In summary, in accordance with its proper statutory mandate, the Commission should never dismiss complaints except in the clearest of cases. The threshold of finding bad faith is a high one. The Commission should fully turn its mind to this question and satisfy itself that there is sufficient evidence of bad faith before even considering the exercise of its discretion. Where settlements are involved, an examination of whether the settlement provides a corrective to the human rights issues should be conducted. However, settlement is only one consideration and shouldn't be used to sidetrack the threshold issue. On applications for reconsideration, the Commission must recognize this is the last resort for victims of discrimination. The Commission can and must do better as guardian of human rights in Ontario. Finally, as a practical matter, settlements will continue to be a major source of resolution for employers and employees alike. However, both the process for settlement and the settlement offer should be fair. The settlement offer should provide some corrective for the human rights issues. The offer should delineate the specific dollars arising from the statutory entitlement versus those which are being offered in exchange for the release. The employer should consider funding independent legal advice, regardless of whether or not the employee accepts the offer. And finally, and perhaps most importantly, give the employee as much time as they need. Thank you.
We almost ran the risk of not giving Geri enough time, but thank you, Geri. Mary-Beth Currie, a partner in the Toronto Labour and Employment Group of McCarthy Tetro, is our next speaker. She did an outstanding job last year, and her punishment, of course, is to be brought back again this year. She's going to talk to us about recent case law and the obligations of the workplace parties under the Occupational Health and Safety Act.
You'll note that Randy added a new part to my title, and that is case law, or recent case law under the Occupational Health and Safety Act. When they asked me to speak again this year, they simply asked if I would talk about employer and employee responsibilities. You have a very thick paper in which I outline employer and employee being supervisor and workers, obligations under the Act, and there is absolutely no way that I could talk about that in 6 minutes. So I will just talk about two events, which are recent events. The first is the trend for the Ministry of Labour to identify they now want to seek jail terms for supervisors who are convicted, and the second being the case that Mr. Justin Laskin referred to this morning about Timinco. Case law under the decided case under the Occupational Health and Safety Act is generally not widely available because most hearings are in front of justices of the peace where there are no reported decisions or few reported decisions. However, there have been 3 cases in the last year in which the Ministry of Labour has sought and not received, but has sought jail terms for supervisors, and those cases with their sites are referred to on page 1 of the paper. What's interesting is that in those cases, the supervisors were all owners. It is also interesting that in 2 of the decisions, the workers who were killed in the workplace accident had been at that workplace for less than a week, and it was their first job. They were under the age of 20. And so you can say the ministry is going to crack down on young workers where appropriate training is not provided. The ministry is turning that over and is saying amongst council, no, you can expect supervisors to be prosecuted in appropriate circumstances. And that includes supervisors who are not just owners. So what does that mean for you who are council who gets the phone call from an employer saying, I've been charged or I've had a fatal accident, what do I do? In the past, Ministry of Labour has not sought to remove counsel who represents both the employer and the supervisor who is charged. Ministry of Environment takes a very different view, but under health and safety legislation, council have been prepared or have been able to go forward representing both parties. This is probably not going to change, but if you get the phone call from the employer saying, we've had a fatal accident, you should at least turn your mind to the fact that is it appropriate at this stage to get independent legal advice for the supervisor? Is it appropriate when you get disclosure or when the summons is received and the information charging the individual, or is it appropriate after you've received the disclosure? If you choose to go forward representing both parties, I would simply suggest that you ensure that you have in writing from both the employer and the employee the fact that they've had the opportunity for independent legal advice and that nothing between the two will be privileged. That's an important part for your employer clients, and that both consent to proceeding. The hot new case, as Mr. Justice Laskin referred to this morning, is R versus Timinco, which came down on April 19th, 2001. And in that case, as he identified, there had been, he said, some confusion. I prefer to say 2 lines of case law, in which the issue was in a prosecution under the Occupational Health and Safety Act, does the Crown have to prove that the employer was aware of the hazard as part of the actus reus of the offense? And it turns out, based on this decision, that the answer is no. This has broad implications for employers. And if you are dealing with your clients who are employers, you should hammer home emphatically that this simply underscores the critical need to develop safety programs and to ensure they're properly implemented so that a due diligence defense can be developed in the event of a prosecution. In this case, it involved a press, and it was, in the words of the decision, a large, ungainly machine. that appeared to have a I-beam that moved across, left to right, across 2 feet, carrying a condenser. And as the operator stood in front of the press, he had no access to any pinch points or any moving parts. But there was a big hole in the back of the press. And in the back of the press, there was in fact access to this moving I-beam. There were 2 chains, and that's literally all, 2 skinny chains between the end of the machine and the wall, which presumably were designed to keep the operator from gaining access to this hole. And the hole was open to permit maintenance. But the company knew that periodically the operators would climb over the chains or under the chains to either do the maintenance themselves or for whatever reason. So there was an awareness that the workers were at an occasion in the back of the press. No one saw the accident, but they found the worker between, like smush between the arm and the stationary part of the frame. And so the Crown argued that the employer had failed to provide the guard. And how did we know that? A man died. They went to trial, and at the end of the Crown's case, defense counsel brought a motion for a directed verdict, arguing that the Crown had not proved an essential element of the case, and that was that the employer knew that this was a hazard or potential hazard to the operator. He was successful at trial, and the Crown appealed. First level of appeal said, in effect, listen, the Occupational Health and Safety Act says it's a hazard if there's an unguarded piece of moving equipment. You have a statutory obligation to guard. You didn't do it in that case, there's a conviction. The defense appealed to the Court of Appeal, and the Court of Appeal upheld, in effect, the ruling of the provincial court judge, and ruled, yep, thanks, I'm going to be there, okay, and ruled that the Occupational Health and Safety Act is a public welfare statute. It is a strict liability statute. There can be no mental intent required to prove that the employer knew anything in order to obtain a conviction, and that if they were to impose a mental element on the employer, then it would impede the enforcement of this kind of legislation. So, to an employer, what does that mean? It means that you do have to take into account steps for training, for documenting, for regular inspections of the workplace, so that you have your due diligence in effect, but also so you can identify the hazards at the workplace in order to avoid these accidents. Thank you.
Dana Groskaufmanis is a member of the Employment and Labor Group at Torque and Mains. Before that, she was a clerk at the federal court, and she worked at the Canadian Competition Tribunal and the Canadian Human Rights Tribunal. Her practice includes all areas of employment law, including pay equity, human rights, wrongful dismissal, etc. And today she's going to assist us in that thorny problem, whether you're on for the sick employee or the employer who has a sick employee, that challenge of dealing with the sick and disabled employee, absenteeism to frustration.
Good morning. On one hand, what I have to tell you this morning is there is absolutely nothing new when it comes to the law of absenteeism. And essentially, the law is basically unchanged since 1904. On the other hand, the principles of the law may not have changed, but their application certainly has. And it's now the law dealing with frustration because of an employee's absenteeism is frankly very limited. I'm going to start with just the first principles very briefly. The common law doctrine related to frustration was set out in the 1904 case of Dartmouth, Ferry, and Marks. And in 1899, Captain John Marks was hired by the Dartmouth Ferry Commission to ferry the Dartmouth Ferry for a whopping $60 a month. And he continued his employment until December 15th, 1900, when he became ill. And he was paid his wages to that day, the last day he worked. And he died, very conveniently for mathematical purposes, exactly 7 months later. And his widow and executrix brought an action for 7 months unpaid wages. And this, of course, went to the Supreme Court of Canada. So you figure $60 a month, 7 months, Supreme Court of Canada. It was a very different time. Well, the Supreme Court of Canada characterized Captain Mark's permanent disability as an act of God and rendered the continuation of his employment contract impossible. Accordingly, the employment contract had come to an end, and because it was frustrated. And the court described the frustration of the employment contract as follows. And there's a quote, actually, I think it's at page, if I haven't screwed up my page numbers, at page 2 of my paper. And it says that the permanent disability goes to the very root of the consideration for the promise of the Dartmouth Ferry Commission to pay wages. And an employee's service to his employer was interdependent with the employer's promise to pay the wages. So the two couldn't sort of be teased apart. Basically, there's a promise to work and we have a promise to pay. If you don't work, you don't get paid. This doctrine of frustration, of course, has gone through, the principles, like I said, haven't changed, but of course now it's also been codified in the Employment Standards Act, dealing with termination and severance pay. Yet there's an exception to the payment of termination and severance pay where the employment contract has been frustrated. The new Employment Standards Act, as a number of speakers have already pointed out, it doesn't spell that out specifically, but does provide that certain prescribed employees will not be paid termination and severance pay. And I think it can reasonably be assumed that the regulations under the new act will preclude payments to employees where the contract's frustrated. So now if we fast forward almost 100 years, the principles of the law of frustration as it relates to employment contracts have not changed, but they are being applied very differently. And the big change hinges on the existence of disability benefits and or sick pay. And because my time is limited, I'm going to draw your attention only to 3 cases. The first is the BC Supreme Court of Canada case of Hager and R.J. Hastings Agencies Limited. And the BC Supreme Court relied on a British decision called Marshall and Harland and Wolff, where they essentially set out 5 factors that you'll have to take into account to determine if a contract of employment has been frustrated. I've set them out sort of verbatim. I believe it's at pages 4 and 5 of my paper. Very briefly, the five considerations are as follows. First, the terms of the contract, including the provision for sick pay. If the contract of employment provides for sick pay, or if there's some provision within the employment agreement or through a benefits package, the court understood that it was clear that the contract could not or would not easily be frustrated, or there was at least a contemplation that an employee could take time away from employment. The second consideration is how long the employment was going to last in the absence of the sickness. I guess the issue being that whether the employment was inherently temporary or whether it was contemplated to be longer. The third is the nature of the employment and about whether the employee was one of many or whether they were a key employee and performed something unique. The fourth being the nature of the illness or the injury and how long it is continued and the prospects for recovery. And fifth and finally, the period of past employment. An employment relationship which is of a longer standing will be more difficult to frustrate than one that is very short. So those were the sort of 5 general principles you had to take into account. How they've recently been applied is that one of those five principles has become of overriding importance. The second case to which I'll draw your attention is the 1998 decision of Madam Justice Swinton in Antonacci and the Great Atlantic and Pacific Company, which was affirmed by the Court of Appeal last year. In Antonacci, the employer raised a number of defenses to the plaintiff's wrongful dismissal action, including frustration of the employment contract because of the employee's medical condition. Madam Justice Swinton dismissed the employer's argument, finding that the existence of the employer's sick leave and disability plans didn't support that conclusion. She said the employment contract was not frustrated, if only because the defendant offered its employees sick leave and long-term disability benefits, and that this was consistent with the conclusion that the contract of employment contemplated a lengthy period of absence by an employee, especially one with a long service record, who was injured on the job. The third and final case to which I'll draw your attention is a very recent Alberta Queen's Bench decision of Brandon and Bennett and Emmett, and all the citations are in the paper. And I think the case is worthy of note because it takes the approach that the court took in Hager and the court took in Antonacci and turns it on its head. If long-term disability or sick leave benefits lead to one conclusion, that is that the employment contract is not frustrated, Brandon instructs that the opposite is actually true, where the court held that where there were no LTD or sick leave benefits and the employment contract was of a relatively short nature, the employment contract was in fact frustrated. So, time's up. Thank you.
Thank you, Dana. You did a marvelous job of covering a century of case law without either frustrating the audience or making us sick. While I think of it, by the way, every year, and we've got a pretty large group here, we invite you to let us know if there's topics that you'd like to have covered next year, or some of you are so bold and brash as to say, I can cover the topic, can I speak please? And we invite you to volunteer. We can't promise you or guarantee you that you can have a spot on next year's show, but we'll certainly consider it subject to constraints. And maybe the easiest way to do it is to just give us one of your business cards with a topic written on it, and we'll throw it into the mix for next year. Matt will undoubtedly remind you about this at the closing, but if you've got a topic, and somebody spoke to me at the break about one that we hadn't covered, we'll try to cover it next year. Our next speaker comes to us from the Ross McBride LLP law firm in Hamilton. Ed Canning tells me that on his drive down the QE today, it was horrendous. It was a 2-hour drive. And he now has a lot more sympathy for claims of constructive dismissal from people who are transferred from Scarborough to Burlington. He's a well-known and established employment law practitioner. His column in the Hamilton Spectator on employment law has been running for some 7 years now. And he's going to give us 6 minutes on a topic very near and dear to my heart, constructive dismissal.
I'm noticing people are very aggressive about this timer.
He tried to start it before I got on the stage.
I was just setting it.
I saw you. Many of you will know that Randy has written a soon-to-be-released book on the issue of constructive dismissal, and I have to comment, well, I thank Randy and Matt for inviting me today. I have to comment that it takes a certain amount of audacity to ask me to talk about in 6 minutes what he decided was worthy of a whole book. On the other hand, if I can do this in 6 minutes, who needs the book? If I leave... You can get the book for any little blanks I may leave empty in the next 6 minutes. There is no real recent developments in the constructive dismissal in Ontario, other than a lot of the law was confirmed in a case that went to the Court of Appeal, Schumacher versus Toronto Dominion Bank. It went in 1999, and I checked my last 2 6-minute lawyers, and nobody's talked about it, so that's going to count as recent for today. And I'm going to run through quickly the general propositions and issues that came out of that case. The trial decision is about 60 pages long, so I'm not going to try to go through the facts other than tell you that Schumacher was with the bank about 11 years, rose to the very top echelons of the bank, was running 5 major product divisions for the bank, was one of 5 or 6 people that was really controlling the future of the bank. And one day, 3 or 4 of the others had, without his knowledge, hired somebody to take over 3 of his 5 product areas. The amount of reports to him was severely reduced. His bonus was going to be affected, and through some back and forth took the position that he had been constructively dismissed. The principles that came out of that case from the Court of Appeal confirm some important factors that you need to look at in any constructive dismissal case. And I always say that next to trying to tell somebody what fiduciary duties exist in Ontario, which is well nigh impossible, advising somebody when a particular situation is or is not a constructive dismissal is a pretty close second. But the factors are as follows. You must consider the specific features of each employment contract, and each situation must be considered to see if the essential terms have been substantially changed. And I think that part of what plays into this is that you see people on particular career paths, which was important for Schumacher, not is that you see, sometimes I advise employers and employees, and employers will say, well, we want to use this person in a management position. We just want to take him out of the cartography department he's been for 20 years and put him in a different management area. Well, but you may be dealing with a person who went to school and is building a career in cartography, and that is their career. That is what they've always been interested in, and they wouldn't work for you if you couldn't give them a cartography job. It doesn't matter perhaps to them that management thinks they'd be equally valued in another area of the company. While the employee's perception itself is not particularly important, the courts will take particular attention to the history of the employment relationship and the history of expectations of the parties. The test is not how the particular plaintiff perceives the change, but how a reasonable person would perceive the change. So if you're advising employees, be careful about getting sucked down the empathy trail too much. You've got to step back and do a good job of being the lawyer, and step back and look at how the world outside, how their colleagues might perceive this change, how somebody looking in from outside might perceive the change, because their particular perspective will, of course, be biased. An employee's willingness to accept some of the changes that come when a constructive dismissal happens are not determinative. Usually it's not just one thing that happens when a constructive dismissal falls out. More often than not, there are several factors that happen. It could be changes of office space, location, wages, bonus or commission structure, reporting structure, responsibility level, and a variety of things. And it's okay for an employee to say, well, I would have accepted just this and this, but 1 and 2, but not 1, 2, 3, 4, and 5. The courts and in Schumacher have recognized that it's not, it can have a cumulative effect. The employer's intentions, and Schumacher confirms this, I think appropriately, the employer's intentions are irrelevant. Some employers will go on a course of conduct aimed to squeeze somebody out without having to pay a severance package, and most of you have seen that situation, either aided in or seen it as a plaintiff's counsel. I know I've done both. That the intention is not important in so much as the plaintiff doesn't have to prove that they were trying to squeeze him out if the end result is that the job is substantially changed. Now, on the other hand, if a plaintiff can prove that the employer apparently did have some bad faith intentions and was trying to squeeze them out or was trying to marginalize them, that will certainly help with the smell test that a judge will apply to a constructive dismissal situation. The trial judge in the Schumacher case interestingly found that because Schumacher was so high up in the organization that there was an implied duty for them to consult him before they hired another vice president at his level. The Court of Appeal, Mr. Justice McMurtry's decision, did not adopt that notion. But if you actually read the trial decision, which I said is 60 pages long, you can see why in this very unique circumstances, the trial judge was willing to imply such an obligation on the employer to consult him first, because he was really sort of like one of five managing partners in the organization. Mifsud was rejected. Mifsud is that case that says that if you're constructively dismissed, in some circumstances, you may have to, instead of walking out and taking the position you've been constructively dismissed and suing for the losses, you may have to take the job and work and do the new job while you're looking for new work. This case is, I've heard referred to by some employment counsel, Mifsud, as the least followed case in employment law. And I actually got a quote out, and I want to read you what Mifsud said. Where the salary is the same, where the working conditions are not substantially different, or the work demeaning, and where the personal relationships involved are not acrimonious, it's reasonable to expect an employee to accept the position offered in mitigation of damages. Well, I don't know about you, but if somebody walked into my office and said, well, Ed, my salary's the same, the working conditions are not substantially different, the work's not demeaning, and the personal relationships are good, I'd say, well, then you haven't been constructively dismissed in the first place. So how do we get to Mifsud? It's a real catch-22, and I think that's why it hasn't been followed very much, because to meet all of those, I mean, except in perhaps some rare circumstances that I can't think of on the top of my head, it's hard to imagine where it would apply. The Mifsud case in particular was a case where there was a nominal change in the relationship. Well, that's my 6 minutes. Thank you very much.
Just a practice point that I take from Schumacher, Bob Colson was counsel for Schumacher, and he wrote a letter which I've referred to anyway as the $1.7 million letter. Ed, you recall in the judgment, the description of his letter was essentially one of, my guy's prepared to work things out with you. We're prepared to play along. He's prepared to be a good Boy Scout. Let's work together, but until you tell us that we're going to work something out, how can he come back to work on your terms? And the bank responded by saying he comes back tomorrow on our terms or he doesn't come back at all. And of course, McMurtry on appeal noted it's kind of hard to argue that he had to come back to mitigate his damages if you told him he couldn't come back and work things out with you. So a practice point I take when I'm on for the employee in that situation is write a $1.7 million letter when the opportunity arises. Our next speaker, Elizabeth Forster, is a partner at Blaney McMurtry, and she's a member of the employment law group at that firm. She represents employers, trade unions, and employees in labor and employment matters. Wrongful dismissals no doubt play a large part of that, I know, and so do constructive dismissals. Justice Laskin referred to the Shaw decision, which I've referred to as the death by 1,000 cuts case. The case where progressive discipline was turned into a constructive dismissal, and to our benefit, Elizabeth is going to elucidate upon that decision in more detail.
Thank you, Matt. And as Justice Laskin mentioned this morning, this case is primarily factually based, so I'm going to review the facts with you briefly. But as I do, keep in mind that this case is unusual in the sense that this is one of the few cases I've ever seen where an employer papered the file perfectly, and yet the employer still lost. So turning to the trials and tribulations of poor Mr. Shaw. Mr. Shaw was an expert in computer electronics. For 12 years, he had a successful career at Xerox. He received a number of promotions, regular raises, and positive performance reviews. In May 1995, Mr. Shaw accepted a position as a technical support analyst in Xerox Advanced Solutions organization. The manager of that department was Mike Harvey. The two men had very different personalities. The trial judge described Mr. Shaw as gentle, reticent, introspective, emotional but uncomplaining, and a little withdrawn. Mr. Harvey, on the other hand, was described as tough-minded, a quick thinker, very articulate, and possessing the qualities of personality and intelligence that make him a highly competent business executive. The problems for Mr. Shaw started when he began to report directly to Mr. Harvey in November 1995. Harvey's group had adopted a philosophy of empowerment under which each employee was expected to take ownership of his various tasks. Shaw found this concept extremely confusing and difficult to work under. So in November 1995, Mr. Harvey met with Mr. Shaw to discuss concerns about his performance under this regime. As all good employers should, he confirmed this in a memo where he set out 3 performance goals for Mr. Shaw. Mr. Harvey then followed up with Mr. Shaw a few months later in March 1996 and gave him a performance review. He followed this up with a letter in which he said to Mr. Shaw, "A sustained improvement is required to maintain employment in your current position." Mr. Shaw was shocked by the letter. And at trial, Mr. Harvey admitted he had no direct knowledge of the criticisms about Mr. Shaw's performance, but rather he was relying on the comments he'd received from others. For the next month and a half, Mr. Shaw only came to work sporadically. He claimed that he suffered from that condition that is the dread of all employers, emotional distress. When he finally returned to work in mid-May, he was summoned to a meeting where he was allocated certain tasks and asked to sign a form confirming that he would perform the tasks. Mr. Shaw refused to sign the form, citing that other employees in the department had been unsuccessful in performing these tasks, and indicating that he felt the time limits set for him were unreasonable. When Mr. Harvey heard of this, he stormed into Mr. Shaw's office, where a heated discussion took place, and he suggested to Mr. Shaw that he look for another position in the organization. Again, Mr. Harvey issued another letter to Mr. Shaw, setting out areas of performance improvement and advising Mr. Shaw that a failure to improve would result in further disciplinary action. Mr. Shaw began to look for other positions in Xerox, but Mr. Harvey would not support him. Then Mr. Shaw discovered that his paycheck had not been deposited in his bank account. He called the payroll department and left a few messages, but they didn't respond to the messages. The following day, Mr. Shaw was summoned to a meeting with Mr. Harvey to discuss his various absences from work. Mr. Shaw explained to Mr. Harvey that his father was seriously ill and asked for a 6-week unpaid leave of absence to deal with his personal problems. Mr. Harvey refused, and he gave him another letter. This letter advised him that his performance had not improved and placed him on probation, threatening termination if there was no improvement. This, for Mr. Shaw, was the straw that broke the camel's back. Mr. Shaw resigned, and shortly thereafter commenced an action for wrongful dismissal. And as you heard this morning, the trial judge allowed the action. The trial judge found that Mr. Shaw had been constructively dismissed and made the following findings. First, Mr. Shaw's position as a member of Harvey's group had become intolerable. Second, he criticized Mr. Harvey for not taking the time to determine the cause of Shaw's difficulties and responding positively to Shaw's request for a transfer. Third, he found the situation from which Mr. Shaw withdrew was as a result of inefficient and unreasonable conduct by Mr. Harvey. And fourth, and most importantly, both counsel at trial argued that in order to make a finding of constructive dismissal, there had to be a breach of a fundamental term of the employment contract. The trial judge disagreed and held that it could also be founded on a repudiation of the entire relationship without cause. The test, said the trial judge, was whether the conduct of the manager was such that a reasonable person in the circumstances should not be expected to persevere in the employment. Also, as you heard this morning, the Court of Appeal dismissed Xerox's appeal and agreed with the trial judge's conclusions. Now, what can we learn from this decision? As Mr. Justice Laskin stated this morning, this is not new law. There are several cases where the courts have found constructive dismissal based on a repudiation of the entire employment arrangement, and many of those cases are cited in my paper. But what it does remind us of are a few basic principles. First of all, it is not enough to paper the file perfectly. Rather, first you should look at the cause of the problems with the employee and look at the employer's efforts to resolve them. You should also ensure that corrective discipline was objective and not based on any personal animosity between the employer and the employee. You should also ensure that the employee is given an appropriate opportunity to respond to the criticism. And finally, as a preventive measure, I think it is important to advise all of our employer clients of the importance of conducting thorough exit interviews to ensure that no resignation is motivated by any of these problems. Thank you.
Thank you, Liz. You did a great job of not only summarizing the case, but also sharing your views on the implications of the case. Our next speaker is a very lively and very animated speaker. I've had the pleasure of hearing her on other podiums. She's not only an entertaining and informative speaker, but she's also the author of Recruitment, Workplace, and DISC, and Powerful Employment Policies, and she's going to share with us 6 minutes on workplace bullying.
So why do some legal assistants make more money than others? They're not smarter, they're not more experienced, they don't have better education, they're making danger pay. And that's because the lawyers that they're working for are such bullies that the firms have to pay them a little bit more just to get them to last longer than 2 or 3 days. Now, I'm sure none of you know anybody at your firm who's like that. But certainly bullying is a growing issue, and it's one that more and more employees are standing up against and dealing with. Now, there is an organization called the Campaign Against Workplace Bullying that works in Canada and the US. And they've done some surveys on this issue. And when they survey this, they find that employees say that, 1 out of 5 employees are suffering from bullying in the workplace. 81% of those people are bullied by a supervisor, and that women are targeted more than men by bullies, but here's equal opportunity and equality of the sexes. Women are just as likely to be bullies as men are. So, oh, applause. All right, that sucks. Okay, so now one of the other things that we have to look at is that when I'm talking about bullying, I'm not talking about discriminatory harassment that's based on one of the protected grounds. I'm talking about something where you're dealing with someone who's just a jerk. It's not because the person has a certain religious background or a certain gender. It's because the person is a jerk. So bullying is more common than sexual or racial harassment. It is a big deal, and it's something that we need to look at. Now, bullying can take many forms. And often when we think bully, we're thinking of the typical screamer, stands right up next to you, spitting in your face because they're so upset. But they can also be somebody that is a lot more subtle. And many of us will have worked with somebody like that, where they sabotage someone else's work, take credit for it, or perhaps they freeze them out, sitting at a meeting, everybody makes contributions, and the manager's going, oh, great, great, yeah, good ideas. And then that one victim speaks up, and the manager just stares at them, says nothing, moves on. That's the type of thing that can be considered bullying. Now, it's not something that we can overlook, because it does have impact on victims. And if we thought of a bully as somebody who hit someone, we'd snap to it and we'd say, wait a minute, that person's being injured and we have to act on that. But psychological abuse has many implications, and many stress-related illnesses result from bullying in the workplace. So we have people who suffer from depression or back pain, inability to sleep, inability to concentrate, alcoholism. Of course, there are a lot of stress lawyers who might suffer these same symptoms as well, but certainly the victims of bullying can experience these things. It can also lead to violence. You will recall the case in Ottawa, the OC Transpo case, where the employee was bullied extensively. He stuttered and he had a facial tic. And his co-workers teased him and teased him and teased him. And one day he walked into the workplace, killed 4 of his co-workers, and then shot himself. And so it's something that really, if we don't deal with it, can have very, very grave consequences. Now, the problem is that bullying isn't related to a protected ground under the Human Rights Code. So what remedies do employees have? When I run harassment seminars, that's something people always say, well, I'm being bullied, I'm being bullied, I'm being harassed. But the Human Rights Code doesn't deal with that. So we have to look at some of the other legal remedies that may be available to an employee who is being harassed, but it's not discriminatory. First of all, constructive dismissal. Now, that's one of the most obvious ones, and certainly the Shaw and Xerox case is a prime example of a bullying situation. There's also an earlier decision of the Court of Appeal in which somebody who worked for the Clark Institute of Psychiatry was bullied by a supervisor. And the Court of Appeal in that case said that that individual could have considered himself to have been constructively dismissed, because it's not part of your contract of employment that you be harassed and bullied and yelled at. Unless, of course, you're receiving danger pay, because that's already built into your contract, in which case that argument might not fly. The other one that has been tested successfully is intentional infliction of nervous shock. So it's an intentional tort. And one of the elements of this is outrageous conduct. That's a very high test. Is the conduct that the person is exhibiting outrageous? Now, our views of what is outrageous have definitely changed. For example, if we look at sexual harassment, in the mid-'80s, a U.S. company did a survey and they provided examples of things and asked the question, is this or is this not harassment? About 50 to 60% of the time, people said, yes, that's harassment. They ran the same survey 10 years later, and that number increased to 90% because our tolerance has changed. And I think that that groundswell is also happening with bullying, where our level of tolerance for these kind of behaviors is changing. We no longer see it as a personality conflict or a strong management style. We see it as pure harassment. So that's one element we have to look at. The second element is whether the defendant intended to cause harm to the individual by bullying them. And that has been in the past imputed to defendants, that even though they may not have expected these consequences, certainly they should have expected some consequences. And conduct producing actual harm that is a visible and provable illness. And we've mentioned some of those illnesses, including depression. The other is negligent infliction of nervous shock, and employers have been found liable and under negligent infliction of nervous shock. If the person becomes disabled, either mentally or physically, then it may revert back to the Human Rights Code and there may be a duty to accommodate. They may also have a claim for defamation if defamatory statements are made in front of coworkers or clients, and there may be health and safety issues. This is not totally defined yet, but there have been issues where we've looked at whether or not harassment can be a hazard under the Health and Safety Act, and I believe that it can be. So in conclusion, the abused legal assistants may have remedies other than just constructive dismissal, and these are things that we need to explore. Thank you.
I knew I risked being called a jerk when I raised that 1 minute left sign, but I took the chance just the same. Loretta Merritt is a partner at Tork & Mains. She has a master's degree in law, and her practice specializes in employment law, labor relations, personal injury, and civil sexual harassment. Ergo, our invitation to her to speak on the topic sexual harassment as cause. Now, the Consumers Association of Canada case is the most recent decision, and I want to confirm that Justice Laskin is no longer in the House. Justice Laskin, are you in the House? Any member of the Court of Appeal in the House? Okay, good, because this case is still before the Court of Appeal. We thought by now we would have the Court of Appeal's judgment on this Consumers Association of Canada case, which involves allegations of sexual harassment as cause, but unfortunately we don't. In any case, we thought it still appropriate for Loretta to provide us with a briefing on sexual harassment as cause.
So I'm here to tell you what the Court of Appeal is going to do. No, I'm just kidding. I won't be that presumptuous. Simpson and Consumers Association of Canada was a wrongful dismissal action. The plaintiff was employed with the defendant nonprofit organization for 4 years as its executive director, which was the highest level employee of the organization. And he had at various times between 7 and 12 people reporting to him. The circumstances of his termination were a little bit unusual in that he was first given a letter relating to salary and other benefits, and he took the position that that letter constituted a constructive dismissal. Before that issue was specifically addressed, though, the company basically had a meeting and decided to terminate his employment, and in fact his employment was actually terminated based on allegations of sexual harassment and poor work performance. In the result, the trial judge found that there was a constructive dismissal. The letter which the plaintiff had been given constituted a radical departure from his terms and conditions of employment. And they also found that there was no just cause for the termination. I've reproduced a copy of the case, and it's long. I don't think anybody will be able to read it while I'm talking, but let me just give you a brief overview of what the nature of the allegations was. There was an allegation that the plaintiff sexually solicited one of his executive assistants. The court actually found that he was testing the waters, and when she rejected his advances, he did not press the issue. There was an allegation that he had attended a strip club with the president of the association and a group of other employees, and the court found that everybody went there voluntarily and as a group of friends. There were some conversations with the in-house counsel about intimate subjects, which in some contexts might be considered crossing the line, but in this case, although the company alleged the conversations were non-consensual, the court specifically found that the nature of the relationship was more one of friends than the in-house counsel was prepared to admit. The plaintiff also had a brief affair with one of his executive secretaries, and it was alleged but not proven that he had provided her with employment benefits as a result of the sexual relationship between them. There was also an allegation, and it was basically found, that he skinny dipped at his cottage with a bunch of co-workers present. And at a board meeting in Quebec City, they had a hospitality suite, and he got in the Roman tub in the hospitality suite naked. Again, the plaintiff said that this was, he considered a private party amongst friends, and the court found that was the case. And lastly, and these aren't all of the allegations, but just to give you a flavor, he squeezed the buttock of an employee at the hospitality suite at an annual general meeting in Banff. Now, his explanation was he had felt someone pinch his behind, and when he looked over, he saw this employee looking at him with a mischievous look on her face, and he thought it was her. And when he pinched her bottom, he then quickly realized she was not the one who had pinched him. And he immediately apologized and spoke to her about that and explained why he had done that. Now, the reason I'm giving you this sort of flavor of what the allegations were is they're the type of allegations that if they were presented to you by a client, your immediate response might be, well, we've got comments, we've got touching, we've got, actual sexual relations with a subordinate. I mean, the immediate lawyer's reaction might be, yes, this case definitely meets the threshold for sexual harassment, and because of his position, et cetera, yeah, termination is the appropriate remedy. However, in this case, the court found that the plaintiff's evidence and explanation for the events was far more credible than the evidence of the president and of the in-house counsel. And with regard to the in-house counsel, the court made some particularly harsh findings, including based on her demeanor as well as her actual evidence. They found that she was demonstrating significant animosity towards this individual plaintiff, and that, in fact, much of what she said was either not true or put in such an unfavorable light as to be misleading. Now, as Matt told you, the case is under appeal. The appeal has been argued, and it is on reserve. But I think there are some important messages that we take from this case, regardless of what happens with the appeal. The first point is, yes, employers and consequently their lawyers have an obligation to act very quickly in these situations. There was one case years ago where an employer waited 7 days before commencing an investigation that was held to be too long. However, you can't act in haste. You can't take a superficial look at allegations and say, okay, that's sexual harassment, that's just cause. You need to do a full investigation and look at all of the circumstances, including mitigating as well as aggravating factors. I would suggest that if there are serious allegations of misconduct, if an employer is considering termination of a senior person, if employer suspects that there may be litigation ensuing, then they are well advised to hire an outside third-party investigator, someone who is trained in investigating these sorts of allegations. Termination is not always the appropriate response. Now, in this case, they did not find sexual harassment, but even if they had found sexual harassment, some lesser form of discipline may be appropriate, and you all know the sliding scale of progressive discipline from verbal warning up to including termination. In determining whether or not termination is the appropriate remedy, you've got to look at, is there some element of consent? Is there some element of condonation? What is the employee's length of service and work record? Is there a sexual harassment policy? Has it been breached? Has there been an acknowledgement? Has there been an apology? All of these things were critically relevant and, in my mind, determinative in this case. In terms of constructive dismissal, you've heard other speakers on that, and all I'll say is it did not matter that the company did not intend to dismiss Mr. Simpson in its letter. The effect was that it was a constructive. And lastly, on the bad faith issue, his notice period was bumped from 12 months to 18 months because of the nature of the allegation and the fact that the association leaked out to the community that he had been fired for sexual harassment and, in fact, destroyed his marketability. Lastly, the in-house lawyer who recklessly and unfairly misinformed the president about the facts was held to be jointly and severally liable with the company. So it's a very strongly worded case. I suggest you give it a read. My 6 minutes are up by 30 seconds. Thanks.
Thank you, Loretta, for not only the principles of what's a 128-page judgment, but also the lessons. Now, in your materials, you'll have inside the front cover a yellow sheet, and our next speaker, along with an upcoming speaker, Barry Kuretzky, is the co-chair of the second annual Employment Law Forum coming up December 6th. I commend it to you. Howard Levitt is counsel to Lang Michener, author of the Law of Dismissal in Canada, and Howard, I'll issue my annual appeal to you to provide us with the second edition. Okay, he said that last year too. He's also editor-in-chief of the DELDs, former columnist for the Star and the National Post, and this morning, Mr. Justice Laskin mentioned the Felker case in his opening remarks, and Howard's going to give us his comments and his views on conflicts of interest as cause.
Thank you, Randy and Matt. My first reaction is one of overwhelming disappointment. Matt had gone out of the room. I thought, God, the enforcer's gone. I can speak as long as I like, but it is not to be. John Laskin listed Felker in his second category of recent Court of Appeal decisions as simply an expansion of the traditional law that fiduciary employees have a duty of full disclosure to their employers. A rather benign manner of stating what may ultimately lead to a sea change in the workplace obligations of Canadian executives. In the summer of 1995, Kirk Felker was at an industry golf tournament where he shared a golf cart with Sherman Cunningham, the CEO and founder of ElectroSource, an electronic component manufacturer's rep. Between strokes and drinks, Felker made two comments of note. One, that for the right opportunity, he'd leave where he was then. And secondly, that one day he hoped to do what Cunningham had done, start up his own manufacturer's rep business in the field. Cunningham was impressed with Felker, but had no position available at the time. But when one later became available, a few months later, Cunningham remembered that conversation, called Felker, and ultimately hired him in a senior capacity. Only 3 months from that point, Felker learned of an opportunity to become the manufacturer's rep for Electrochip, another company in the field, and an opportunity which ElectroSource itself had earlier turned down. Felker prepared, using his company laptop, a PowerPoint presentation to Electrochip, but he worked on it on evenings and weekends, although he acknowledged at trial that he probably wasn't working quite as hard as he might otherwise for ElectroSource while he was working for those 2 or 3 weeks on his presentation. His new boss, Cunningham, learned what he was up to, but didn't confront him, wanting to see if he'd come forward on his own volition. And when he didn't, he terminated him, saying, I can't trust this executive anymore. The Court of Appeal said as follows: as a fiduciary, Felker's duty of good faith required he be open, honest, and forthright with ElectroSource and make full disclosure of all material facts that, as his employer, it'd be entitled to know to successfully operate its business. In this regard, Felker was required to make full disclosure to ElectroSource that he was engaged at the time in preparing a presentation of Microchip with the intention of acquiring it for his fledgling company and thereby carrying on business in competition with his employer. On the level of the specific issue in the case, some interesting questions arise. Does an executive give up looking for other job prospects? Does he look but not tell his or her boss and risk losing everything? Do they look and tell and risk any chance of ever advancing the organization if they're ultimately not interested in the job or if the job doesn't pan out? I think that instead of making employees more candid with their employers, the court's ruling might make them even more surreptitious. For example, they might well contract with their, informally at least, with their new prospective employer to keep the information confidential and be sure that it is, knowing they might be fired otherwise. And that raises another interesting issue. If the new employer blurts out the information, can the employee then sue them for the damages they no longer can get from their existing employer? And if they have that sort of a deal, does the prospective employer become a joint tortfeasor? Probably. But on the underlying ratio of the case, there's far more interesting issues. Again, what material facts must an employee disclose in order that the employer can successfully operate its business? Well, that's rather wide-ranging. But let's look at some of the implications. Do they, for example, now have a duty to inform their employer if they learn that one of the other employees is intending to leave? Do they have a duty to inform their employer of misconduct, even off-duty misconduct, of other employees? Do you have to advise of aspects of your background the employer failed to ask during the initial hiring interview? Or the background of other employees you happen to learn of? Do you have to advise of all market intelligence or business opportunities that come to your attention in any way? I have one case coming up for trial next month where I'm going to be relying on this case. The employee was on working notice, and during the period of working notice got a job offer which they accepted. They continued to work. Now that may be cause in and of itself, and some, at least, employment standard tribunals have said that it is. But another aspect of that is they continue negotiating severance, and when the employer offered them a bridging arrangement, they came back and said, I'd like a lump sum for tax planning purposes. Obviously not the real reason, one might think. I suspect that in itself is cause for discharge, although some judge will likely tell me in a month or two. The other interesting aspect of this, since cause is a breach of contract, therefore, I'll be even less. Therefore, okay. Therefore, it would lead your employer to be able to sue the executive for failing to disclose, which, for example, in the situation of not disclosing business opportunities, could be a very significant lawsuit. Thank you for your attention.
He did name that tune in less than a minute. Stacey Ball of Ball and Alexander is the author of a leading text on employment law, and he was also counsel at the Supreme Court of Canada on the now infamous Wallace and United Grain Growers case. So we thought there'd be no better person than Stacey to come back and give us a little briefing on what's up with that Wallace case. What impact has it had, and what's the status of the Wallace bump up? Stacey Ball.
Thank you, Matthew. I'd like to thank Randy and Matthew for inviting me to this very well-attended conference. After working on the Mactinger case with Howard Levitt at the Supreme Court of Canada in 1992, I thought we might be looking at perhaps a new model for the contract of employment. The Supreme Court of Canada indicated very clearly that employees are a protected class. There's special policy considerations applying to the contract of employment. I thought about a fiduciary model. I didn't think that would fly. So I started looking at some American theories. I thought, well, maybe we can work with a good faith and fair dealing obligation. So I wrote an article in 1994 in the MacKillop Law Journal, because that got retained by Manitoba Council, who retained me because Manitoba Court of Appeal said I was definitely wrong, saying that employers should have an obligation of good faith and fair dealing. They quoted me right in the judgment. So I thought, well, I got to take this to the Supreme Court of Canada. My name's at stake here. We did a leave application. We got leave. And in 1997, the Supreme Court of Canada held that employers now have an obligation of good faith and fair dealing. in the manner of dismissal. The obligation, according to Justice Iacobucci, is incapable of precise decision, but he said, however, the obligation of good faith and fair dealing includes at a minimum a course in which employers ought to be candid, reasonable, honest, and forthright in the manner of dismissal, and refrain from conduct that is unfair or in bad faith by being, for example, untruthful, misleading, or unduly insensitive. So we have a lot of important adjectives here. Unduly insensitive, misleading, you can't lie to employees for the reasons for dismissal. You can't act in a manner which is abusive. You've got to be honest and forthright. Importantly, Justice Iacobucci said that not all dismissals constitute a bad faith discharge. The court must look at each case, each fact pattern specifically, and not all bad faith dismissals are worth the same amount. What does this good faith obligation mean to employees? Well, what it means is that they get an extended notice period. The Supreme Court of Canada, the majority opinion, would not classify bad faith damages as aggravated damages like the minority would have. I think that's a better view. I think that bad faith damages ought to have been aggravated. However, intangible losses are indeed recoverable through an extended notice period. Also, if you're unemployed longer because of bad faith conduct of the employer, you get an extended notice period. There are numerous examples of what will constitute bad faith conduct now. For example, not paying an employee employment standards money, which is owed at the time of dismissal, will constitute bad faith conduct. Allowing the reasons for dismissal to get out in the community, like it did to Mr. Wallace, will engender extended damages. Serious cause allegations, which cause mental distress, will engender intangible losses, hence an extended notice period. Firing an employee without giving the employee a chance to respond to cause allegations has been found to be a breach of the duty of good faith and fair dealing. So the courts have been very, very creative in applying Justice Iacobucci's words. There's no doubt about it. The courts, I find, so far, have actually weighed each case, and the amount an employee can get can be 1 or 2 months. Damages awards have been as high as 36 in the Clendenin case, which I'll get to, but that was modified on appeal. In 2000, the BC Court of Appeal reduced a 36-month award, I believe 36 plus 6. The trial judge awarded an extended damage period of 36 months, plus a base award of 6. The Court of Appeal for British Columbia reduced the total award to 12. So it does not, the majority opinion doesn't indicate how they did it. They meshed the extended notice period with the base notice period, but the amount works out to 12. It looks like they gave a bonus of 6. Does Clendenin change the law? I don't think it does, because what happened is that the majority opinion of the BC Court of Appeal said that findings of fact by the trial judge that this man's career was ruined because of fraud allegations got out in the community could not be supported by the evidence. So I think the reduction is really factual based. It doesn't change the law. So Wallace has had an impact. I've given you some examples of the bumped up notice period in the paper. When we're looking at extended damages, I think we should be looking more than just Wallace. I don't think we should forget, for example, tort law and tort remedies. Supreme Court of Canada, the majority opinion said you're not getting aggravated damages. However, if you can prove the tort of intentional infliction of mental suffering, you can get extended aggravated damages in the form of mental distress. A good example of that is the decision of Ramatula, Van Fed Credit Union, a 1983 decision, I believe, of Justice McLaughlin, when she was a justice of the BC Supreme Court. Damages for intentional infliction of nervous shock is still available. You should be looking at, for example, a decision of the House of Lords called Malik versus Bank of Credit and Commerce. I believe it's a 1997 decision of the Law Lords. In that case, they held that employers had an obligation of trust and confidence, which is part of the contract of employment. Given what we've seen in Canada so far, I would not be surprised that Canadian common law imposed that type of obligation eventually. I think I'm pretty much out of time, 1 minute, but I'm finished. Thanks.
Stacey's watch? Stacey? Thank you, Stacey. You did an excellent job of staying within the time and, in fact, left your watch with us. But there's no question Wallace has had an impact, and we appreciate your comments and closing suggestions on other remedies as well. Our next speaker is Malcolm MacKillop. I'm pleased to introduce both my partner and my close friend, who is a leading member of not only our group, but the employment law bar in general. He's the author of Damage Control and Creative Solutions and a prolific video artist. He's done 11 employment law videos on various topics. He's also a regular Globe and Mail columnist, and if you open your report on business this morning, you'll see one of his columns. He's going to enlighten us on what's new on notice periods. Malcolm?
Good afternoon. As most of you understand, that in the absence of cause, an employer has an obligation to provide reasonable notice or pay in lieu of notice. The key case has been for many years the Bardell and Globe and Mail case, and the factors outlined in that case: age, length of service, character of employment, and chances of reemployment are still the factors that most courts will rely on in assessing reasonable notice. Now, the Bardell factors have been certainly approved by the Supreme Court of Canada in the Mattinger and Hodge case. What you want to know is what's happened over the last year with respect to some of these factors. Age. Generally speaking, an older employee is entitled to longer notice. That's a no-brainer. The magic age, if you had to ask yourself, at what point does age become really an important factor in triggering longer notice? I think it's probably 55 and upwards. Depending on the circumstances, it may be 50 and upwards. But in most cases, you'll see some recognition of the age factor at 55 and up. Notwithstanding that, there is a case that happened over the last year, the Taylor case, which is in the paper, which deals with a 66-year-old plaintiff who was denied longer notice because of his age, because of his short length of service and the nature of the courier industry. So not every case will result in a higher notice period. Now, two important factors dealing with age. The court will not generally compensate an employee until the age of retirement. So for instance, if you have somebody, your client is terminating at age 64 with only maybe 6 years service, it doesn't necessarily mean the court will grant 12 months as notice to get the person up to age 65. The reverse of that is if you, in the absence of a retirement policy, if an employer terminates an employee at age 64 after 20 years service, it doesn't mean that it's going to be capped at age 65, providing only 1 year service. Now, another factor that is considered the character of employment. Now, generally, courts have recognized that an executive or a managerial employee, a professional employee, will be entitled to longer notice than an administrative or a clerical employee. Now, that theory was displaced briefly by the Cronk decision, which set aside that reasoning and awarded a clerical employee substantial notice. Now, that decision in Cronk was eventually overturned by the Court of Appeal, and notwithstanding that, and a clear statement from the Court of Appeal that there should be a difference, there are a number of cases that I have seen where courts are prepared to grant significant notice to even administrative or clerical employees. There is sound reasoning in the New Brunswick Court of Appeal decision in Brample, which I recommend that you read. But two examples that I've seen over the last year where substantial notice was given to people who were not in the managerial levels is a case coming out of Alberta, where there is a warehouseman with 25 years service who was granted 22 months notice, and a decision out of the Manitoba Court of Appeal, which is in your paper as well, dealing with a nurse and receptionist with 25 years service who was given 18 months notice. Another point that should be emphasized is that there is also some debate over whether part-time employees should be treated in a similar fashion as full-time employees. And historically, part-time years of service have been discounted on a basis of 1/3. There seems to be some reasoning now that part-time employees should be treated in the same fashion as full-time employees in terms of notice. Finally, the length of service. Generally, longer service will result in a lengthier period of notice. 24 months continues to be viewed by most courts as the upper limit, and there are exceptions. But generally speaking, 24 months is seen as a cap. Since April of 2000, there are no reported cases above the 24-month limit. Now, the other aspect of this is the rule of thumb, that essentially 1 month per year of service should be granted to a dismissed employee. Now, Justice Laskin, as you probably know, in Minot, clearly put an end to the rule of thumb. And over the last year, there have been several cases which endorse that reasoning. So in summary, the Bardell factors still apply, and undue emphasis should not be given to one factor over another. You should apply all 4 factors and look at the particular circumstances of the individual you're dealing with. A 24-month cap is probably safe to rely on. With respect to the 12-month cap for a non-managerial employee, I would suggest to you that is probably unsafe to rely on. And finally, although the rule of thumb has been discarded by the courts, as a practical matter, I still use it in terms of assessing at least a starting point, and then I go back and apply the factors. In a strict legal argument in front of the court, that's not going to do you much good. Thank you very much.
Barry Kuretzky is a partner at the law firm of Kuretzky Vassos, and he is listed in Lexpert's 2001 directory as one of the top employment lawyers in the city or province. He is, as Randy pointed out earlier when introducing Howard Levitt, he is co-chair of the second annual, he was co-chair of the first annual Employment Law Forum, which this second time round will be on December 6, 2001. Another program put on by the Law Society. And he is also co-author of a forthcoming book on mediations. I just so happen to have a copy of the very colorful brochure here for anyone who would like to peruse it after we're done. It's got a lovely picture of boxing gloves inside of a briefcase, an excellent image of mediation. Barry is going to address the Greba case, to which Justice Laskin referred briefly in his comments, and specifically that aspect of the case that Justice Laskin left to Barry, namely stock options.
Thanks very much, Matt. Appreciate that warm introduction. He wants to try to settle a case with me later. The only thing that really counts in an era of full employment in terms of getting damages for your client may very well be where the stock options are going to lie. In the high-tech executive world, that's where the money is. Getting 5, 10, 15, 18 months on Bardell may be irrelevant to the hundreds of thousands of dollars and even millions in stock options that are available. The current entertainment of the stock market has proved to be very entertaining in terms of these cases as well, and I'll chat briefly about the idea of damages. The whole critical idea boils down to the confusion that the Court of Appeals created. No one's here from the Court of Appeal because of how they've handled the decisions. I want to look at some key wording in Brock, Veer, Greba, Yacobucci, and Gilchrist. Option plan, the Court of Appeal tells you, is determinative. Here's some option plan wording. And at the end of the day, you tell me what you think really makes a difference. Brock, the worst decision to come out in 1991, set the law back in terms of damages until it got fixed in a case Matt may be familiar with in Veer. He relied upon Brock to his great chagrin. In any event, the language says, the employee shall have 15 days from the date notice of dismissal is given in which to exercise the option. Well, in the concept of lawful and unlawful termination, O'Leary at trial said, look, that's very simple. The termination doesn't take place until the end of the reasonable period of notice, and therefore the time frame begins to run the 15 days after notice. So if notice should be 10 months, that's terrific. Then 15 days then applies. Unfortunately for Mr. O'Leary, the Court of Appeals saw that matter differently. Now, the similar wording in Vera. All of his rights hereunder shall terminate as of the effective date of such termination. Legal fiction, mumbo jumbo, these two have a distinctly different meaning according to the Court of Appeal. I can't possibly see it because you can read it any way you possibly want. Now, Greba. He was a very nice fellow. He was president of the Monada Porcupine Mines, 9 years, earning a salary of $60,000 plus stock options. So obviously the options must have been the driving factor because salary clearly wasn't. Now his says, at the effective date thereof may be exercised in whole or part in 30 days thereafter. Greba was dismissed without cause, didn't exercise the stock options within the 30-day period specified. At trial, Madam Justice Whitten held that Greba's rights under the stock option plan didn't expire 30 days after the date of termination, but continued to 30 days after the period of reasonable notice. It's only common sense. From my perspective, the law has always been that whatever should fall into the period of reasonable notice, an employee should get by way of damages. It's logical, and quite frankly, that's what Swinton and the Court of Appeals seems to be clearly outlining. And regardless of where the language lies, absolutely irrelevant. It looks like the trend is going to be that the stock options are going to fall in place despite the language in Brock. Although in every case, they tell you that Brock's the right law. I guess they feel that they have to support their brethren who said it in '91, and that you have to look at the strict wording of the plan. And in Yakibuchi out west, in '99 decision, British Columbia talks about the same thing, talk about 2 calendar months from the date of her termination. The interesting aspect of that case is that he was on salary continuance. And while on salary continuance, they played with the stock option plan to the advantage of other employees because of a takeover. Salary continuance equaled really still being an employee, and therefore the critical factor was that he would get the options. Gilchrist, same kind of language, exercisable within 30 days. So what's the difference? What's the magic? Well, the magic was very simply, Brock lost at the Court of Appeal $204,000. Veer won $437,000. Yakibuchi got $180,000, and Greba won $62,000. So when you look at those numbers, you see how irrelevant, in fact, the notice period can be. But what becomes critical is what is the court going to do on notice periods? Is it going to be a factor that is going to lengthen notice periods? For example, on the idea of the unvested plan, if I have a client who was fired December 31st, and on July 30th, and I have this client, and on July 31st the stock options were due, maybe his notice period might be 4 to 6 months. Clearly, in order to get over the hump of the cases, I'm going to, hopefully the court will tell me that it's at least a 7-month or 8-month notice period. And will it be a Wallace factor to say, well, you knew where the options lay, and therefore, what were you going to do? And that may lengthen the notice period. Critical advice to clients, when you're asked at the outset of an employment arrangement to look at the stock option plan, you've got a liability problem if you don't carefully look at this issue and advise your client what might happen down the road. For example, if the stock option plan reads identical to the decision in Brock, you're going to want to advise your client carefully that he needs to go back to the employer and outline to that employer that that option plan is not going to work for him. And even though the option plan is already registered and is regulated, you can properly, at the outset of the relationship, seek to carve out that situation. Now, the issue, if I have 30 seconds on damages. Veer awarded damages based on I've got the timer, based upon what happens at the day of judgment. Look at the stock market. Try to figure out what's going to happen in terms of damages. If the market is rising greatly and you know your client has an opportunity, you might want to write the other lawyer and say, we would cash these options in today during this period of reasonable notice. And that might have been helpful last July as the market was at its peak. You might have a different attitude today depending upon where your Nortel pieces of the pie are. But the difference is hundreds of thousands of dollars. I have a case that really the notice period, if it's 6 or 10 months, isn't going to matter, but the $1.5 million in options is going to count. So thank you very much for your attention this morning, and be very careful in looking at those option plans at the outset and at the conclusion of the relationship.
Thank you, Barry. You are right that that's where the money is. There's no question. We've saved the best for last. Ian Johncox is an example of someone who last year volunteered. He's a partner with the Mason Bennett Johncox law firm in Whitby. He's an ink-stained wretch like some of the other speakers. He writes a column called Your Business and the Law in the Durham Business Times and Legal Briefs in the Lindsay this week. And he's going to tell us everything we need to know about how to deal with variable compensation, commissions, and bonuses in notice periods.
Thank you and good afternoon. I was honored to be asked to join this year's faculty. I was dumb enough to volunteer last year. When I got a letter that said the Law Society of Upper Canada on it, I just about had a heart attack because I wasn't quite sure what it meant. I opened it up and I realized I'd been asked to do this, and that scared the hell out of me too. I'm not an expert in employment law. It's a large part of my practice, but I've been practicing 5 years, and so I'm no expert. I chose this topic because I wanted to learn about it, not because I had any special expertise. And I hope that what I've learned I can pass on something useful to you. And so I apologize if you don't learn anything from this. Determining damages in typical cases is easy. It's a mathematical function of the notice period. You figure out the notice period, multiply it by the salary, and you're there. In variable compensation, all that changes. So how do you assess damages? Well, it's the same analysis as in any case you might have. What is required to put the plaintiff in the same position he or she would have been had the wrong not occurred? And this is the first rule. And the wrong in this case is the breach of the employment contract by the employer, specifically the failure to give reasonable notice. So I think one effective way of doing it is to prepare a timeline on a piece of paper, and you start at the date of termination and you end at the date that you consider to be the high end of the reasonable notice range. Now along that line you're going to mark out certain points in time where certain things like stock options might kick in, certain bonuses that might be paid would be paid or would have been earned, things like that. Things that would have happened, key dates along that timeline. Now no matter what period of notice the judge decides is reasonable, you have a tool which you can lead into evidence that the judge can look at and peg out the proper damages based on whatever notice period the judge chooses to be reasonable. Now, practically speaking, you've got to expect arguments when you deal with these types of files. There's lots of room for argument with variable compensation. It's variable. And the sooner you put the other side on the defensive, I think the better. So if you draft a claim, set out every element of the variable compensation in detail, ascribing an amount of damages to each element. Now what happens is the court now has your claim, understands completely what you're looking for, and all you need to do is lead the supporting evidence to back up your claim. And in the judge's mind, the judge is going to be looking at the defendant, the employer, and saying, what can you do to disprove this? So the onus has not really shifted, but it has in a practical way. Now the same is true for the defendant. If you're faced with a claim like this, you want to be specific in your statement of defense. If you take a different position, set out why and set out in detail. Even if the claim is what I would consider to be poorly drafted with all sorts of damages which will be particularized at trial, your defense should be clear. That way the judge understands your position and the plaintiff now has the real challenge of showing that they are entitled to something other than what you've pleaded. Now compensation varies for a number of reasons. Some of those bases of compensation are impossible to predict during the notice period because they would have been different had the employee stayed. I'm going to deal with a few. Salary increase, normal increases, cost of living, and across the board increases or increases set out previously in the contract. Set them out, prove them, you shouldn't have any problem getting them. What's more arguable is the annual merit increase. So you've got your annual review, and you would normally expect an increase. If an annual review occurred every year, it's reasonable to argue that you were entitled to have that review again and the increase that was consequent on that review. On the other hand, it's just as reasonable for an employer to say, once I've given you working notice, I'm not going to give you a review and I'm not going to give you another raise. And there are some cases that go either way. Overtime. If it was a regular part of that employee's income, claim it. A history of consistent overtime and a history of paying overtime will prove your claim. Interestingly, bonuses. One of the earliest cases dealing with bonuses is Bardall. We think of Bardall about the main factors, but we don't really think of it about the bonuses. In that case, the bonus was denied because the court held it was voluntary and there was not part of the employment contract. Now, since that time, as bonuses have become far more prevalent, the courts have backed off from that position and found reasons to allow the claims. The key to success is to show that the bonus has become an integral part of the employee's wage structure. And in my opinion, the test is no longer whether there's discretion in handing out the bonus, but more a test of whether the payment of the bonus is so erratic that it's not predictable. So indeed, there was one case, Turner, which I've noted in the paper. The employer had the discretion not to give the bonus. The court allowed the claim anyway, saying that this employer had never exercised the discretion against that employee. So I think the trend, as bonus plans become more structured and less loosey-goosey, less discretionary, the question is less entitlement and more calculation. Now, there's different kinds of bonuses. The easiest bonus is one based on external factors, so you get a percentage of company profit every month. That's easy. You can figure out the company profit during the notice period and claim it. Now, you may not know the numbers. You may not need to get that in discovery, but claim the specifics other than the numbers in your claim. I'm running out of time. Bonuses on performance. Once the employee is gone, you lose the basis for calculating that. You've got to go on past history, and I think that's the best you can do. The problem is hybrid bonuses, what I call hybrid bonuses, where they're somewhat rooted in performance, somewhat rooted in statistics. And if you look at the paper, the Icon, Beach and Icon case is excellent. There's a great quote. The judge basically described both arguments, cut them out in half, and gave the employee half. I'm sure neither party was happy, which is probably a good compromise. The only thing I'd say about stock options, because Barry's covered that very well, is if the difference in the value of the stock options would have gone down during the notice period, you might want to argue that as a set-off against the other employee's claims. Now my bell is gone. The only thing I would say to you is that it takes more time. The courts are looking for a reason to give a claim to an employee. So if you can base it in quantum merit, unjust enrichment, if the employee's done the work, the employer has benefited, you can probably find a way. Thank you for giving me point one of your day. Thank you also to Randy and Matt for again putting on a great program.
For 4 years running, 300 or so of you have decided to attend this program that Randy and I have had the honor of co-chairing. To be entirely frank, no matter how much we'd like to take credit for those statistics, the reality is the format is the star. We all love to keep lawyers to about a .1 when they present a topic, and clearly the format is the star, but in all fairness, the content is provided by a number of talented, dedicated lawyers who specialize in this field and each year provide us with some of their time in preparing the papers and in coming here and presenting the briefings that we've asked them to present. So when you're preparing your evaluations, which are the gray form in your binder, please go easy on our presenters. I can tell you, standing here looking at you, you're a daunting crowd. It's a very large number of you that we see out there from this podium, and it's a bit frightening, quite frankly. Also, I would note that Justice Laskin, for some reason, has been included in the evaluation, and I strongly recommend that you circle the letter E. We also want to remind you that we require always volunteers and suggested topics for upcoming events, and if Randy and I have the honor of being here again next year, sometime around Mother's Day, give or take a day or two, we will require volunteers and topics. So please provide us with your business cards with the topics, or with your own number if you want to yourself be part of the faculty, or send us an email. Either way, we'd appreciate your volunteering your time and effort. Lastly, we want to thank you again for coming. We promised that we would have you out of here by about 12:43, and give or take a minute or two, we've succeeded. So thank you again, and we'll see you next year.